item number 36. Respondent has filed the affidavit. So I will file reply on just 1 week time. Many documents are there. Respondent finance filed the affidavit. Just 1 week time. Obligement.
This is your lordship. Lordship, I beg to mention a matter for listing, lordship. A listing of a writ petition, lordship. The bench for matter. Lordship, there is some urgency. Short date be given, lordship. Lordship. Obliged.
My lord, I beg to mention item number 49 with the consent of the other side, my lord. Only for that day, my lord. Maybe I just maybe listed in the next week, my lord. Any day convenient to the other.
May I please, your lordship? Item number 17 and 22, my lord. Respondent has filed affidavit, my lord, yesterday, my lord. We have to file our counter, my lord. 2 weeks time may be granted, my lord. 17 and 22, my lord.
It's a serious matter.
Serious matter, my lord.
Please wait.
Yes, my lord.
May it please your lordship. Lordship, I am saying for listing of this matter in the admission column.
17.
May I please your lordship? With the consent of other side, I beg to mention item number 16 for adjournment for the day.
Wait for your turn. We'll pass the order.
May I
Obliged.
please, your lordship? I beg to mention for listing of a writ petition for tomorrow, my lord. There is an urgency, my lord. There is a transfer matter. He is at Dhubri Hosai, my lord. Now he is at the Doboka Hosai, but he is transferred to Dhubri district, my lord. He is
When the
last
transfer
time-
order was issued?
Your Honor, my lord.
When the transfer order was issued?
Transfer order was issued on July, my lord. July 24th.
What is the urgency?
Urgency is there, my lord. He is in last stage of his retirement, my lord. He is retired in first part of 2014, my lord.
Okay.
May I please your lordship? So I beg to mention item number 47, lordship. It's a hearing matter. So my senior is admitted in hospital for a heart surgery, lordship. So kindly pass over the matter for 6 weeks.
Who is admitted?
P. Mohanto, lordship. For pacemaker implantation, lordship.
Okay, we'll pass the order. No, don't.
Obliged.
May I please, your lordship? I beg to mention for listing, my lord, matter relating to pension method.
Uh, 16th.
Most of them.
Mr. Martha?
My lord, I pray for listing of a bench for electricity matter, my lord. Disconnection of electricity has taken place and the petitioner is a cardiac patient having some difficulty. We filed it yesterday, my lord, for tomorrow if feasible, my lord. To be applied.
Lordship, please to reject this earlier, lordship. Case there,
Case the up-to-date case.
When? Yes, ma'am. When?
16, lordship. 16-8.
Much obliged, your lordship. Much obliged.
Second bail application, your lordship, kindly up-to-date case there, your lordship, kindly see in para 8, I have stated my new gowns. And in fact, my lord, that is, their police is after the only, my lord, small fry. Driver, handyman, and my lord, parking place, my lord, owner was, they are after them, my lord. But high security, that my lord, code oil, but from Amguri to Digboi, under high security of the, my lord, that security person was there. So how it can be stolen, my lord, without the, not that they have not even after any, I am neither contractor nor my lord.
16.
16,
Get
lordship.
it, get it. Up-to-date case there.
Lordship, 16-8. Lordship, may I submit that one item is there? Item number 43, Lordship, bail hearing. Can it be taken up in 2, Lordship?
We'll take it up at 2.
Lordship, much obliged.
Definitely, Lordship, after some time, Lordship, our file is coming because the matter was fixed for tomorrow, Lordship. So I have, our file was,
That's right, it's tomorrow.
it was fixed for tomorrow, Lordship.
How it has been listed today?
That's, I have no knowledge.
Sometime happen, my lord.
Lordship.
Okay,
Sometime
we'll have it, we'll
not
take it
list-
tomorrow. We'll not change the order.
I think, my
As per
lord,
the order dated 05
no, my lord, there's the list has come. Again, it will not list it tomorrow.
Will be listed. List this matter tomorrow in terms of the order dated 05/08/2023. License matter.
Fine, fine.
আমার ফাইল কত কোথায় গেছে না আমি
09/08.
ওলা চলছে
First order to came in.
Tomorrow is a motion demanding.
We'll have it in the admission. Make a mention in the morning, no problem.
Today I start at 9 o'clock from home, my lord. Because yes, again, my lord, I have to start 9 o'clock.
May I please, as a lordship? My lord, these are the matters, my lord. We are claiming, my lord, regularization of our service and post, my lord, as a Gaura. My lord, under the South Salmana and Mankachar subdivision, my lord. Now it is a district. My lord, what has happened, my lord, initially there is an interim order operating. My lord, that there should not be any appointment without the leave of the court, my lord.
Yes. Who is appearing for this state? Yes, Mr. Huya, please.
My lord. My lord, in the very first petition, my lord, we are claiming that the my lord government has initiated a process for the purpose of our regularization, my lord. My lord, what has happened, my lord, in the erstwhile district of my lord Gwalpara, when these districts were undivided, my lord, there was no Gaungura system was functioning, my lord, or the government has not made any policy for the purpose of the recruitment of the Gaunguras. So, my lord, therefore, the villagers as well as the local public, my lord, has decided to appoint, my lord, in their places one honorary Gaunguras in their respective villages, my lord. And on the strength of, my lord, that policy, my lord, the government has also, my lord, issued an office memorandum regarding, my lord, appointment of the such honorary Gaunguras in those districts, my lord, wherein, my lord, there was no Gaungura systems were existing. Accordingly, my lord, on the that stand, my lord, we were, my lord, selected by the local villagers of the said area of our respective villages, my lord, and we had been appointed and continuing. And thereafter, my lord, when only in the year, my lord, 2015, the government has come up with a policy, my lord, that in the entire state, there should be a recruitment drive for the purpose of, my lord, appointment of the honorary Gaunguras by a, my lord, regular selection process. Now, my lord, before that, we, my lord, made a representation before the authorities, my lord, that our services should be regularized, my lord, and on the strength of that, my lord, the government has initiated an exercise for the purpose of our regularization. If my lordship allows me to draw my lordship's precious attention, my lord, to the page 44 of my writ petition, my lord.
Yes, which page?
Yes, my lord, I beg to draw page 44, my lord, of my WPC 3828, my lord. My lord, in this, this is a letter, my lord, issued pursuant to a representation, my lord, made by our association and as well as by the respective, my lord, Gaunguras. My lord, may kindly see, my lord, may kindly, my lord, see that this is a letter issued from the government, that is the Joint Secretary to the Government of Assam Revenue and Disaster Management on 7th of March 2016, addressed to the, my lord, respective Deputy Commissioner of Dhubri, because, my lord, at that relevant period of time, it was a Dhubri district, my lord, prayer for recognition of the appointment as the Gaunguras. In enclosing herewith, the representation dated 9/1/2016, submitted by so-and-so, Assam and member, all India so-and-so, which speaks for itself, I am directed to request you kindly inquire in the matter and offer your views in the light of recent circular of the guidelines. Now, my lord, basing on this, the government has undertaken an exercise at next page, my lord, page 45, annexure 4, my lord. My lord, this is a letter basing on the instruction of the government, again issued by the concerned Deputy Commissioner's office, my lord, addressed to the circle officers of various, my lord, revenue circle, as a continuous process, my lord, with reference to the subject cited above. I am to enclose herewith a copy of letter under reference received from the Joint Secretary to the Government of Assam Revenue and Disaster Management Dispur, along with its enclosure, and a copy of guideline by number so-and-so, which is self-explanatory. I am to request you kindly to inquire into the matter and offer your views in the light of guidelines of the circular issued recently by the government notification dated so-and-so, copy enclosed. So, my lord, when this letter was generated at next page, my lord, the concerned circle officer at page 46, annexure 5. My lord, a ground level inquiry had been carried out regarding the, my lord, position of the various Gaunguras who were appointed as an honorary or in the various mode, my lord,
And this is a report, my lord, prepared by the circle officer of the Dhubri Revenue Circle, addressed to the Deputy Commissioner, submission of inquiry report for recognition of like appointment as Gaunburas. Your office letter number dated so and so, with reference to the subject cited above, I have the honor to submit here with the present biodata of the 9 applicants as per enclosed list after inquiry for the recognition of like appointment as Gaunburas under Dhubri Revenue Circle. All concerned papers, documents submitted by the applicant are enclosed herewith for favor of your kind information and necessary action, my lord. Accordingly, my lord, this is the statement. My lord may be pleased to find from page number, my lord, of the next page, annexure 6, page 47 to page 48. In this manner, my lord, the various revenue circle had prepared, my lord, our list. Our names had been and our lot had been reflected in the various, my lord, lots of the concerned revenue circles and addressed to the concerned deputy commissioner, my lord, for the doing the needful. Then, my lord, this is the at page 55, my lord, may kindly peruse, my lord, annexure 9, a letter of 12th of September 2016. My lord, the list of Gaunburas. This is a letter issued by the secretary to the government of Assam to the deputy commissioner, my lord. I am directed to request you kindly to furnish a soft copy of so and so file containing the information regarding the Gaunburas pertaining to your district as per the format shown below urgently to this department by email at so and so. So, my lord, this is the my lord, letter issued by the government addressed to, my lord, all the deputy commissioners that in this pattern and format in MS Excel file, the detailed biodata of the Gaunburas was sought for, my lord. And accordingly, my lord, that process has been carried out at page 58, annexure 10, my lord. My lord, to the circle officer by the Gaunburas with reference, I am enclosed here with a copy of the letter under reference received from the government of Assam Revenue and Disaster Management Department, which speaks for itself. You are requested to submit the list of Gaunburas as per the prescribed form in the MS Excel file to this end with 2012-2007 for onward transmission submission to the government. Accordingly, my lord, this letter had been addressed by the deputy commissioner to the circle officer, my lord. Exactly, my lord, similar reminder had been given, my lord, at page 60, annexure 11, letter dated 1912, my lord, addressed by the circle officer to the deputy commissioner, my lord. After collecting of the data, my lord, with reference to the subject cited above, I have the honor to submit here with the list of Gaunburas containing the required information respect of the Mankachar Revenue Circle as per the prescribed format, both in hard and soft copy as sought for by you, by letter under reference for favor of your kind information and necessary action. So, my lord, this is the last, my lord, from page 61 to, my lord, up to, my lord, page number 65 is the list of Gaunburas of Mankachar Revenue Circle, in wherein, my lord, our name and detailed particulars have been incorporated, and it had been accordingly onward transmitted to the government, my lord, for the purpose of doing the needful. Now, my lord, when this exercise was going on for the purpose of our to taking a decision that whether we can be regularized or any permanent absorption can be made, then suddenly, my lord, at page 69, annexure 15, my lord, may kindly peruse, is a notification, my lord. Is a notification issued from the end of the, my lord, the office of the deputy commissioner that, in pursuance of the government notification number dated so and so, WT message number dated so and so, a selection board is hereby constituted by the following members for appointment of the Gaunburas of the South Salmara Mankachar district of Hatsingimari. Now, my lord, what they have done, my lord, as the government has initiated a process in the year 2016 by, my lord, issuing a notification for the purpose of selection of Gaunburas. Now, suddenly, my lord, this exercise, which had been carried out for the purpose of our regularization, my lord, kept on hold, and government, my lord, has decided to go for a, my lord, a regular selection process. At page 70, annexure 16, my lord, may kindly have a look, my lord, is the notification and advertisement had been issued, my lord. Page 70, my lord, annexure 16 to my read petition, my lord.
Yes.
Lord, this is wherein, my lord, we are by my lord filing this petition, my lord, we have challenged this advertisement on the count that, my lord, if we are compelled and required to participate pursuant to this advertisement, my lord, then we cannot be, my lord, accommodated, or we cannot participate in the recruitment process as per the terms and conditions, my lord, are notified in this advertisement, my lord. That's why on our ground and contention of the challenge in our writ petition in the instant petition, my lord, is that as the government has already taken an exercise for the purpose of our regularization by whatever means, my lord, that process should be culminated into a logical conclusion, my lord. My lord, it is a discretion of the government that whether they can, my lord, regularize or can reject our regularization exercise, my lord, by of a reason order also, my lord. But without doing so, my lord, they have initiated this advertisement exercise for the purpose of recruitment of the new incumbents by replacing us, my lord, wherein we had been working from the year 2004 to 2005, my lord, when there was no Gaon system was existing as per the, my lord, Assam Land and Revenue Regulation Act of 1886, my lord, in the erstwhile district of the Gwalpara, which also includes, my lord, the district of present South Salmara, Mankasar, as well as the Dhubri. So, my lord, when we moved this petition, my lord, this honorable court, my lord, was kind enough to pass an order, my lord, interim order, that the directing the state respondent not to make appointment in the lots or the villages or charge wherein, my lord, we were working at that relevant period of time. Then, my lord, when this interim order was operating, then, my lord, the deputy commissioner of the, my lord, at that relevant period of time, my lord, I should spell the name of that deputy commissioner only because there are other issues which will be come up, my lord, is Atika Sultana and another additional deputy commissioner, Saibur Rahman, my lord. A large scale, my lord, corruption, cash for job scam has been come up, my lord. And that deputy commissioner, my lord, has come before this honorable court in his own capacity, my lord, that this interim order, which was operating at that relevant period of time, should be vacated, my lord. And accordingly, my lord, this honorable court was pleased to, my lord, modify the interim order, my lord, giving liberty to the respondents to go for the selection process, but that appointment was directed not to be made without the leave of this honorable court, my lord. And accordingly, my lord, the select list was prepared. Then again, that deputy commissioner come up before this honorable court, my lord, that asking and praying before this honorable court that as the selection list had already been published, so therefore, my lord, the liberty should be given to them to make their appointment, my lord. And accordingly, my lord, this honorable court again modified the interim order, allowing them to appointment with an observation that each and every appointment shall be subject to outcome of the present writ petition, my lord. Now, my lord, what has happened? Once the appointment has been given, a second writ petition has been filed before this honorable court, my lord, which is again listed today as WPC number 8394 of 2019. My lord, when this writ petition was filed, my lord, there are certain allegations of the corruption as well as the, my lord, monetary, my lord, transaction was also, my lord, allegation has been leveled. So, my lord, this honorable court wanted to peruse the records that, my lord, in what manner the recruitment process had been carried out. There was a specific direction, my lord, repeated direction had been issued by this honorable court to bring the records before this honorable court. But, my lord, from my best of knowledge, my lord, till date, those records has not yet been placed, my lord, in full and in final form, my lord. So, my lord, what has happened? Then, my lord, a criminal case had been filed before the Chief Minister's Special Vigilance Cell, my lord. And the Chief Minister's Special Vigilance Cell, my lord, had carried out a very extensive, my lord, inquiry, and wherein, my lord, this deputy commissioner as well as the additional deputy commissioners were found guilty in monetary transactions, my lord, and they were arrested and put behind the bar also, my lord. And this additional deputy commissioner was more than, my lord, 6 months was behind the bar specifically for the, my lord, corruption carried out during the recruitment of this Gaonburas, my lord, in the South Salmara and Mankasar district, my lord. And, my lord, then accordingly, charge sheet had also been filed before the learned, my lord, special judge at Kamrup, Guwahati, my lord, and the trial is now pending. And on the other hand, my lord, these present petitioners, my lord, by collecting a, my lord, certified copy of the said charge sheet, has again filed a writ petition before this honorable court that, my lord, as these persons, my lord, Gaonburas had been appointed in violation of the various laws as well as the guidelines. So therefore, my lord, they cannot continue in the said post, and their services should be terminated, my lord. And in that case also, my lord, till date, the state respondent has not filed any affidavit.
Which is the WPC number?
My lord, that WPC number, my lord, that Last city file is Saibur Rahman against. Milord, I will provide it, Milord, just after some. Milord, it has not been tagged today, Milord, but that case is also required to be tagged, Milord. That will, Milord, bring the entire aspect of the matter, that how in what manner, Milord, the intensity of corruption is so much, Milord. It is apparent on the charge sheet, Milord, which we have annexed in our petition, Milord. So, my lord, may be pleased to take that matter, Milord, and keep this.
We'll see to that first.
My lord,
Just tell us
my lord.
how a Gaubura is appointed.
Milord, at the relevant period of time, Milord, when our appointments were made in our concerned districts, Milord, there was no regulation was, Milord, governing at that relevant period of time. So therefore, Milord, the villagers, Milord, has decided to, Milord, take up the responsibility, because Gaubura is a very essential post at that relevant period of time, Milord. So therefore, Milord, they have been appointed on honorary basis, Milord, as there was no rule, specific rule governing at that relevant period of time. Only, Milord, in the year 2016, after the judgment delivered by the Honorable Apex Court, my lordship is well aware, Milord, that the Rajeshwar Sharma's case, Milord, a specific direction has been given by the Honorable Apex Court, Milord, that government should come up with an executive instruction or a recruitment rule, as these posts are civil posts. So therefore, Milord, an executive instruction should be made. Milord, government, without framing any, Milord, service rule, they have come up with an executive instruction only in the year 2016. Now, Milord, in our case, Milord, when we were appointed long back in the year 2005, there was no any such executive instruction was operating, Milord. So therefore, Milord, there was no space. With all respect, Milord, what I humbly and respectfully beg to submit, Milord, that, Milord, in case of our appointment, there is no violation of the rule, Milord. So therefore, Milord, as my lordship, the government has regularized, Milord, many school teachers, Milord, those were appointed in violation of the, Milord, I can say, Milord, respectfully beg to submit that in case of their appointment in Vansar schools, Milord, they were appointed in violation of the rules also. Now government has come up with a provincialization act for the purpose of regularization or provincialization of those teachers, Milord. So the government can come up with our policy also, Milord. That exercise they did carried out, but that has not finalized, Milord. That is our grievance, Milord. Milord, and there is also a similar writ petition was moved, Milord, wherein that writ petition has been disposed of by directing the concerned deputy commissioner, by concerned commissioner and secretary, Milord, to look into the matter as regards the regularization of this type of Gaumburas, Milord. And what has happened, Milord, to that direction, Milord, today I am not aware, Milord.
Do you have that repetition number?
Milord, I can provide that also, Milord. Arata repetition disposed. Nair sir, you can answer.
Okay, give it us later. No problem.
My lord. So, my lord, my limited and my lord humble submission before my lordship is that, my lord, as the government is well aware that we the people as an honorary Gaubura had been working from the year 2005 till this exercise of regularization had been carried out. My lord, they have undertaken an exercise. So, my lord, this gives an legitimate expectation to us that they will take a reasonable decision in our case, my lord. But without doing so, my lord, they wanted to throw us back, throw out from our, my lord, respective lords and Gaumburas by replacing us with the new incumbents, which had been subsequently done, my lord. That's why, my lord, this exercise which had been carried out subsequently, my lord, is full of, my lord, embezzlement, corruption in violation of the rules, my lord. If my lordship may be pleased to take those matters, my lord, it will reveal that in what intensity this corruption has been carried out, my lord. And, my lord, in our case, my lord, till date, the government has not filed any affidavit denying this exercise of, my lord, the various collection of the data and records. They have not, my lord, denied. Last petition to Seven.
Application dispose হয়েছিল এখানে আসারে করেছে কোম্পানি নাম্বার My lord, that charge sheet repetition number is, my lord, WPC 7111 of 2022, my lord.
7111.
7111 oblique 2022, my lord.
Yes, who is appearing for the state? Have you taken any decision regarding regularization
No,
of the
Lordship.
service?
In our affidavit, we have been clearly stated, Lordship, that there is no process has been taken for regularization of the petitioner's case, Lordship.
Was there any direction of the court?
No, Lordship.
My lord, there is a writ petition, my lord, disposed of, not in our case, my lord, but it is similarly situated for honorary Gaunburas. There is a specific direction. My respected senior friend, perhaps, my lord, not aware, my lord, but I can give that judgment also, my lord.
If you can give it to us, it's better.
My lord. My lord.
My lord, there is no any direction given by this honorable court. My lord, that the order was passed by in Ornakanto Nath Lordship WPC number 4694,
Yes,
2018.
No, it is not a direction for consider their case, my lord. That kind of direction.
Only, my lord, that direction was given whether the government can given the weightage to the, my lord, that the honorary Gaunbura or not. My lord, that direction was given. There is nothing, my lord, nowhere in mention, my lord, in the judgment that this should be very regularized, Lordship. In our affidavit, we clearly stated, Lordship.
Sorry. 4694 of 2018, my lord. Along with other connected matters are also
There
here.
are so many cases, Lordship. And court was, my lord, this honorable court was directed to, my lord, initiate the selection process, Lordship. And petitioners, those who are, my lord, working in the honorary TISA, they were asked to apply for that, my lord, selection process.
Please take your seats.
My lord.
Mr. Indeed, brother has considered similar matters for the district of Dhubri. Similar issue, same issue, there is nothing. Here is only the prayer for regularization. There it was the prayer the challenging the advertisement. We do not know whether there was any such application for the purpose of regularization in the district of Dhubri or not. But here, the Commissioner Secretary in the Revenue was directed to take a decision. Because the petitioners therein have worked, though on honorary, but rendered certain service as Gaon Buras. So they are within the class itself is a separate class. So accordingly, some kind of weightage that has to be decided by the government and nobody else. So here it is a question of regularity. The second writ petition is something different, will come under the same reply 4694/2018. But what is your stand with the regulations?
Affidavit. In our affidavit, we clearly state, there is no process for regulations of the petitioner service in the on who are working in the honorary. My lord, the petitioner were appointed by the
No, that we have seen by public or
Lordship.
corporate,
and my lord, this regulation process has been taken when the appointment was made by the my lord that any government authority
See,
as per the selection
first
procedure.
of all, when these petitioners were appointed as a Gaunbura, there was no Gaunbura posts at all.
Lordship.
But the revenue system, Gaunbura is an essential.
Lordship.
And so the revenue department, though not revenue department sanctioned any post or deputy commissioner did not create any post. To help the administration, these Gaunburas were appointed. Right? Now, the observation made by the court, WPC number 4694,
Lordship.
remain intact. But what the court observed in that particular order is that since the advertisement has been issued, it directed all those petitioners to apply. But before selection, directed the commissioner secretary to consider their case.
Whether this weightage has been granted.
Now, whether any weightage has been granted,
Lordship.
that's what I want to know.
Then my lord, that I have to
That's an old order. Can you tell us? Otherwise, we'll dispose it in the same line. If the petitioner agrees, otherwise nothing,
Lordship.
we'll hear and dispose of. Whether there are any of order was of 11th of August 2022.
Lordship.
So by this time, probably some decisions have already been taken.
My lord.
And you let us.
Lordship, my lord, that I have to take instruction regarding what weightage has been granted. Whether it is granted or not, my lord, I do not know. I have to take instruction regarding that. He will, my lord, if the weightage is granted to the my lord, that person, my lord, that those who are regular, my lord, they will get the benefit to the all. If it is not granted, my lord, they will not. And even then that in South Salmora district, already been my lord, the selection procedure has been completed, Lordship. And only my lord, Dhubri, some other districts. Now, my lord, that some of the my lord, districts, my lord, there's some the Gaunbura have that the selection procedure has been completed, Lord. In our
In
affidavit,
this
Lordship.
petition itself,
Lordship.
in this petition itself, the court by order dated 17th of December 2020.
Lordship.
Observe that any appointment made pursuant to the select list dated 9/7/2019,
Subject to outcome.
subject to out of counter rate petition. Right?
Lordship, my lord, in the 382.
Yes, 3828.
That is there, Lordship. Lordship may given some time to obtain instruction regarding whether any weightage has been given to the, my lord, that persons or not, my lord.
That will have a different issue because we do not know whether the petitioners have participated in the selection process or not.
My lord, as per that, my lord, that petition, my lord, they did not apply, my lord. Some of them have been
But in
applied.
the other case, they were directed to apply. Those who have not
My lord,
applied.
that initially, my lord, Dhubri district, that selection, my lord, that advertisement was challenged, it was, my lord, state, Lordship.
Here it was vacated.
Lordship. No, Lordship, later on, my lord, it was given direction, my lord, that to initiate the, my lord, selection process in pursuant to that advertisement, Lordship.
ইয়াৰ লগত ঘৰুৱা ইয়াৰ লগৰ আইকেইটা আছে এইটো 382 লগৰ আইকেইটা দিব প্লিজ টেক ইউৰ সিট
Lordship.
Mr. Rashid, you are appearing for selected candidate.
I'm not selected, I am like the candidate now here. But he has equated that some of the lots, he has put to say that this is my. So I have evidence is present, then I find. Otherwise, prayer is said.
Mr. Henry, that amendment of the executive instructions. Earlier you placed a budget notification. Do you remember when it was published in the Gazette?
Which notification, Lordship?
That 2018
Lordship.
selection of Gaon.
Lordship. 2010 Gazette. Earlier, Lordship, it was submitted.
What is the stand regarding the process of regularization? There is a direction by the court for filing an affidavit.
Lordship.
Have you
Lordship,
filed that affidavit?
kindly see our affidavit, Lordships, in WPC, Lordship, 3828.
You have
Lordship,
filed additional, second additional affidavit, I believe.
No, Lordship, that is the,
There are two affidavits.
one is, my lord, regarding, my lord, that ST and SC, my lord, the reservation, second additional affidavit. And my lord, that, this was filed on, my lord,
Yes.
2019, I think. Lordship, may I kindly, my lord, in my affidavit, Lordship, paragraph number 10, Lordship, page 3. Affidavit filed by Srimati Gayatri Borivara.
Just a minute, coming there. Yes.
Married.
Just a minute. Okay. Srimati GB Bora.
Lordship. Lordship, may kindly give the item serial of paragraph number 10, Lordship.
Yes.
That with regard to the statement made in paragraph number 13 of the petition, the defendant beg to state the information regarding honorary and the self-appointed Gambura were sought for regarding the government fight letter number so and so. The information was sought regarding those Gambura appointed by DC, SDO who are receive monthly remuneration from the government. Thus, the Dhuburi district has also stated the step has not been taken in light of that letter number so and so, so and so, so and so. And also, Lordship, paragraph number 6. The state government is not liable to appoint, organize, or regularize such.
Yeah. Do you have that notification or communication
Which one, Lordship?
that we have shown you just now? The earlier date was a place before the court.
Get set night and situation visual area. You can't go visual.
is there any other stay order operating in any of the case?
No, my
Any
lord.
stay-
No, my lord.
After
Only-
vacating this stay order, there is nothing in operation.
No, my lord.
Now,
my
only
lord,
cases
in
that you are
some of-
seeking regularization.
My lord.
Now, what we have found that
Lordship,
you are aware or not, we do not know.
Lordship, Mr. Nash will submit on the
Mr. Singh.
Lord, in my senior friends who respective some stay order is operating in respect of some
Which
laws.
item?
In item number of although in item number 12 was there was initially no stay, but on the last occasion, Lordship, his appointment was interfered with and his appointment was directed to be suspended. Item number 12 and I think item number 14 also there is a stay of the appointment of the private respondent.
Hello. Lord, I have gone through the order, my lord. In that order, my lord, a letter had been communicated by my lord, the senior government advocate to the before this honorable court, my lord. My lord, our specific pleadings in our case, my lord, relying, which I have just brought into my lordship's kind notice, my lord, that regarding the various communication regarding collection of the data, my lord, from the grassroots level is for the purpose of regularization, adjustment or appointment of the Gaunburas, wherein, my lord, we had been working. If my lord may be pleased to peruse the each and every affidavit, my lord, there is no contention or averment had been, my lord, put forward in the affidavit denial, or, my lord, they have not said. My lord, I have a 3 affidavit in my hand, my lord, and I have already gone through, but there is no denial in those affidavit regarding the said exercise which had been carried out, my lord. In my writ petition, my lord, I have specifically pleaded my lord, the very exercise starts from Annexure 3. Now, if my lord may be pleased to peruse the Annexure 3 is a my lord, paragraph in my writ petition at page 31, paragraph 8 to paragraph 9, my lord, then paragraph 10 up to, my lord, paragraph 13 to 15, my lord, is the specific pleading supported by, my lord, records generated by the government that there is a definite exercise has been carried out. As regards, my lord, these averments, my lord, if my lord may be pleased to peruse the affidavit filed by, my lord, the department, they have not denied or said anything that the said exercise is not carried out or that is not for the purpose of regularization or for some other process, my lord. So, my lord, as they are silent regarding that, my lord, and now by, my lord, issuing a letter addressed to the, my lord, respected senior government advocate, my lord, they have said that, my lord, no exercise had been carried out. My lord, it should be by of an affidavit, and in their affidavit, they are silent, my lord. They have completely bypassed, my lord, those specific governments in each and every affidavit, my lord. My lord, in one of the affidavit, in paragraph 3, filed by, my lord, my lord, Gayatri Bori Bora, filed in the month of May 2019, my lord, in the said affidavit, my lord, at paragraph, my lord, 9, that deponent says, my lord, that with regard to the statement made in paragraph 8, 9, 10, 11, and 12 of the writ petition, the deponent has no comments to offer, my lord. And these are the letters generated from the end of government, from the end of deputy commissioner, from the circle officer, my lord. Then, my lord, they can come up with an affidavit clarifying before this honorable court, my lord, that why, under what circumstances, my lord, those communications were exercised, were carried out. They can, my lord, make it clear before my lordship, my lord. Milord, from my Milord limited understanding, Milord, as regards the law of regularization, Milord, this is a very difficult, Milord, concept that there should be a mandamus for the purpose of regularization, Milord. But Milord, situations are there, Milord. The government has time to time, Milord, formulated policies for the various stakeholders of the various employees, Milord, working in the state of Assam, in the Panchayat and Rural Development Department, in the Social Welfare Department, Milord. They have regularized the contractual employees or, Milord, some other persons who were appointed by dehorsing the rules also, Milord. So, Milord, we are the Gaumburas, Milord, at the down to rodent families, Milord, at down to rodent strata of the society, Milord. Now, Milord, our services has already been extracted from the year 2005 to 2016, Milord. The government was well aware, Milord, that we had been appointed by the, Milord, villagers, Milord, and government could have come up with an executive instruction or notification restraining us, Milord, from discharging our duties. Now, Milord, after extracting our valuable years for more than, Milord, 15 years, they have come up with this policy that we should be thrashed out and, Milord, should be replaced with the new incumbents, Milord. That is injustice, Milord. Sorry. And, Milord, that apart, Milord, Milord, as we can say, Milord, that the regularization is a, Milord, very difficult concept, Milord. Milord, what I respectfully beg to submit, Milord, government has also realized that the recruitment drive, Milord, which had been carried out, Milord, to replace us, Milord, is full of, Milord, irregularities, embezzlement, and therefore, Milord, the government, by way of the Chief Minister's Special Vigilance Cell, Milord, carried out a, Milord, detailed investigation, and wherein, Milord, charge sheet has been filed, Milord, under section 420, 468, Milord, and 470 of the IPC, Milord, framing charges against the selection board members as well as the other persons who were involved. Now, Milord, the government on the one hand, Milord, realized that those appointments were fully, Milord, bundled with corruptions, Milord. So therefore, now the government cannot defend those appointments, Milord, at this honorable forum, Milord. So, Milord, those persons are required to be, Milord, and they have already represented by their respective councils also, Milord. Each and every page of the charge sheet, Milord, has elaborately described that in what manner, Milord, those appointments were made, Milord.
Lordship, my lord, this petition has been filed for, my lord, regularization of service. My lord, that those who are, my lord, that already been selected, and, my lord, that selection process has been completed. My lord, it is a different, my lord. My lord, the lordship, firstly, lordship, kindly see when the, my lord, the Gaumura system was introduced in the Dhubri and 8 districts, lordship.
Just a minute, we'll come back to you. Please for a minute. Mr. Andy,
Lordship.
please come to the read petition. Page
3828.
40. Present with
Lordship.
38. Page 45.
Lordship.
See the reference. On the reference, there are two letters.
Lordship.
Petitioners have annexed the second letter. Page number 44. Can you say something about the first letter? What is it?
44.
Page number 44 is the second letter of that reference at page 45. Do you have a copy of the first letter? The reference has two letters. Page number 45.
Lordship.
Under reference, there are two
Reference
letters.
number two letters, Lordship.
The first letter hasn't been annexed by the petitioners, but they have annexed the second letter.
Lordship.
The second letter is at page 44. Right? So can you tell us what is that first letter? Do you have a copy of that first letter? Have you seen? 236. Can you get a copy of that letter?
Lordship. No.
Mr. Henry, what we could gather, there 2009, there was a repetition. By such honorary Gaumburas of South Salmara, Mankachar. South Salmara, I have not seen Mankachar. All are from South Salmara.
In that time, it was under Dhubri district.
The direction of the court to fill up the post of Gaumbura in different villages of Dhubri district, but petitioners were from South Salmara. In terms of the government guidelines issued for that purpose and following the due process of law, as and when the authority sanctions any post and decides to fill up such post, needless to say that the cases of the petitioners shall also be considered if they applied for the aforesaid post. That means those posts which will be sanctioned, and necessary weightage for past experience shall be given if permissible under the law, and that decision remain intact. That was a decision of 19th of June 2009. Thereafter, the government on 1/6/2016 issued certain guidelines.
2016.
1/6/2016 issued certain guidelines. Some of the honorary Gaumburas of Kokrajhar approached this court. Now, in that matter, the court with regard to those honorary Gaunburas of Kokrajhar directed the petitioners of WPC 2054-2017 to submit their individual applications before the Commissioner Secretary Revenue Department.
In Kokrajhar,
Those are serving 10 years or more than that. So it gave a specific date that it will be submitted on or before 17/4/2007. In
my
that
lord, in
particular-
the Kokrajhar,
So that was a case regarding the relaxation of age because many of the candidates. So the court was very specific that if such representations are filed individually, those will be considered on merit under clause 2 of Roman 2 of the notification dated 6/1/2016. Now, on the basis of that, all those honorary Gaunburas of Kokrajhar district might have submitted, we do not know, in terms of 6/1/2016. But what we have seen from the affidavit filed by the government in the present case, that 6/1/2016 notification was kept in abeyance by subsequent order.
okay,
And later the 2018 notification came into force.
superseded the Malad Presidency.
And that 2018 notification was not under challenge. Now, Mr. Via, Mr. Das, show us in which of the repetition you have challenged.
My lord, they have challenged
My lord,
one case.
4790 of 2018.
4790 of
Item number, item number 4, and there is a stay in that case.
My lord, in my this
47?
petition,
4790 2018.
Can you tell us the item number?
Item number 4.
That is from which district?
District also the selection has not been taken place.
my lord, in my item number 15, WPC 8394, my lord.
Just a minute, we'll come one by one.
My lord.
Which is 5119/2019.
Lord,
Which is 5119/2019.
No, Lord, I do not have that.
5/1/2017.
In which case there is another stay? Any idea?
Milord, in my another petition, Milord, WPC 8394 of 2019, Milord, the entire notification of 2018 is under challenge, Milord. A separate petition. And Milord, in fact, in this case, no stay had been granted, Milord.
Now,
Milord, after
the
this,
order of stay
my lord,
that was passed in the case of 4790/2018. In fact, today the 5119 2019 is not before us.
Lordship.
And the interim stay that was granted to the granted earlier. All these cases was on the basis of 5119/2019. 5119/2019 is altogether a different issue, different matter relating to the appointment of Gaunbura.
Lordship.
A person was selected as a Gaunbura. His name was there in the list, but by a corrigendum, the deputy commissioner again issued an order.
Correct.
Under which that petitioner was removed. The petitioner of WPC 5119 was removed, and the private respondent named in that 5119 was substituted by the private respondent. That which is stayed by the court has nothing to do with this set of writ petitions.
5119 was a part of that dispute lordship.
Earlier, that is why that is a different case altogether.
That is the individual
This is a selection, after
There was a
selection.
selection, on that basis of selection, the selected candidate name was removed and it was substituted by the deputy commissioner.
So by
In which that process,
Lordship.
so substituting the name of the writ petitioner. by-
That process was
That process has nothing to do with this.
Lordship.
lordship in item number 4, also there is a stay order directing that in the interim
Item
respondents are
4.
directed not to fill up the.
Item 4.
Item number 4.
479.
In which lordship the 2016 notification was.
That is what we are talking about. That 4790, what they were talking about, it is only on the basis of 5119. And 5119/2019 relates to altogether a different matter.
No, 5119 is a lordship individual case, lordship wherein lordship the selection process took place.
Mr. Das,
This is in respect of Dhubri district. That is in respect of South Salmara.
Lordship, the initial stay order in item number 4 was granted by Honorable Justice Zamir. That was on the basis of a different case. This is a subsequent order passed on 2020.
that's what is order is
Lordship.
continuing. That's
Yes.
that order that was issued by this court earlier.
Lordship.
That has been continued till date. The
Yes.
last order is Brother Shyam has passed that order.
Yes, Lordship.
So that order is meaningless. That was only in 5119. Has nothing to do with these sets of writ petition.
More case, more case.
So
Lordship, I have not been able to understand, Lordship. 5119, Lordship, is an individual case, Lordship.
that order,
Yes.
it is very category. The stay order passed in 5119 on 31, 31st of July probably, shall remaining until further or something like that. The penultimate paragraph, I think. So. 25th of, that order was passed 25th of November or 25th of something. Got it?
28.
কাটি কাটি যায় নাথাকে ন নাথাকিলে এইটো বাৰে বাৰে মাৰি দিব লাগে
Lordship, the initial stay was on 23/7/2018. Thereafter,
not extended.
thereafter these cases were grouped.
See,
All the cases were grouped, and that
maybe
this
that order was not
479018 Lordship is from Dhubri district. The other cases more or less are from South Salmara, Mankasar.
That
Anyway, Lordship,
order-
all the cases have been grouped, and
but that
finally,
order,
Lordship, subsequent order have been passed.
See. 5119.
5119 is my case, Lordship. I know, Lordship. Nurul Islam Ahmed. It was an individual case initially, and corrigendum was issued, wherein, Lordship, my name appeared. Thereafter, they issued another corrigendum.
In that particular group cases, that was an order on, what is that?
And in 5119, my learned friend also appears for a private respondent. And on their prayer, Lordship, that writ petition has been segregated from this particular group. That writ petition is still pending, and interim order is still continuing.
But that interim order was, whatever they were in the 4790 was not extended. Only with regard to 5119, it was extended.
Anyway, Lordship, in these cases, Lordship, the government has not filed their affidavit. Lordship, today I want to, Lordship, place my case in item number 12 and 14. Because in item number 12, Lordship, there is a specific direction on the last occasion. The appointment of the private respondent was interfered with. And Lordship, now they have to place whether his appointment has been cancelled or not. And Lordship, the records was also called for in item number 12. And Lordship, in item number 14 also, Lordship, the Honorable Court wanted to pass the similar order, but only because of paucity of time, Lordship, the same order could not be passed. 12 or 14.
Mr. Handy,
Lordship.
just show us which are the cases from Dhubri.
Dhubri.
Because there are two sets of cases. The one are from Dhubri, the other sets are cases from South Salwar. Difficulty is that stay order in the Dhubri probably is not been extended thereafter.
In some other cases in the Dhubri, already been disposed of.
And Dhubri, Lordship, the selection process has not taken place. Only in South Salmara, Lordship, the selection has taken place. Selection and
Because
appointment.
that selection, that advertisement has been issued, that the process is
Now,
going on.
after the stay order, Lordship, there is no further selection process. Item number 4 to 12 or 14 to Mandra, sir.
Srirang.
This order sheet of 28th of January 2020 is only to show that the WPC number 4790/2018 should be tagged along with these items. On 28th of January 2020, 4790/2018 was not before the court. That is why the stay 4790 was not there on 28th of January 2020.
Maybe it was.
Then 4790 came on 25th of February 2020. Court did not pass any stay order. So whatever order it was there on 4790, it was issued on 23rd of July 2018, with effect from 25th of February 2020. There was no stay order in these proceedings.
Anyway, Lordship, in the special also government has not filed.
So there is maybe,
Lordship.
but there is no
Lordship,
stay order.
Lordship, today I am Lordship placing item number 12, Lordship, because this case is fixed for consideration of further consideration today, Lordship. There is an order passed by the Honorable Court on the last occasion.
First, let us differentiate the Dhubri and South Salmara. Mr. Mia, can you tell us which are the cases from South Salmara?
Only two writ petitions, my lord, W3828 listed today, my lord, and 8394 of 2019, 3828 of 2018, my lord. And WPC 8394 of 2019, my lord.
This is South Salmara.
South Salmara, Mankasar, my lord. My lord, one thing is required to be submitted fairly before my lordship, my lord. When the clubbing all these matters, my lord, has created all the confusions, my lord.
We'll come to that.
Yes, my lord. My lord, my individual case, my lord, that is WPC 3828, specifically, my lord, with
South
the,
Salmara.
yes,
Yes,
my lord,
then which are the other districts?
that is, my lord, WPC 8394 of 2019 is also for South Salmara, Mankachar.
Item number?
Item number 15 in today's board, my lord.
Any other, can you say whichever matter is from South
Lordship,
Salmara?
I think, my lord, that item number 10 also South Salmara.
But it is not from my end. my lord.
Is it not?
Yes, Dharan.
Well, item number 12 and 14 are South Salmara. But those are individual cases.
সব সাইড কর সাউথ সালমারা এটা উপর চালে ডিস্ট্রিক্ট কোন চালে কম পেয়ে যাবে শর্মা সাইডিও
Item 10. 8844. Okay.
উপর ডিস্ট্রিক্ট কোন সাইড See, there are two different notifications for the district of South Salmara Mankachar. The particular lots in divided in the South Salmara and Mankachar, all this. Similarly, for Dhubri, there are various subdivisions, right? For that two notifications, will clear it out under which notifications these Gaumburas are serving. Okay. Because the notifications issued by the Deputy Commissioner for those lots, all the subdivisions, the of Dhubri district, there are lots, subdivision, the lots are under specific subdivisions. So how many lots are there for the sanction, for the purpose of Gaumburas? It is there. The petitioners are not saying anything from which lot they are doing it. 11 তো চিরাঙে দেখা যাচ্ছে।
My lord, in my petition, 3828 in page 30, paragraph 5, I have specifically mentioned the lots under the my lord, what has happened? My lord, although some the residential status is different, my lord, but they fall within the subdivision of South Salmara Mankachar, my lord. That's why, my lord, this discrepancies, my lord, regarding the address.
বাকি ধুবড়ি গেটা সাইড করো।
Item 13 also, my lord, Mankachar.
Yes.
My lord, we can prepare a list. my
What
lord.
we have found as of now,
My lord.
item 3, 7, 8, 10, 12,
Lordship.
13, 14, and 15 are from South Salmara
South
Mankachar,
Salmara Mankachar.
right?
Lordship.
Item number 11 is from Chirang.
Chirang.
So probably the rest are from Dhuri. But Mr. Huya, Mr. Das, the first order of the court of 2009,
My lord.
it has attained finally. There will be a post created by the government. And in terms of the guidelines, they will apply for the post if they are eligible. And they will have the weightage if it is in the guideline.
In item number 4, Lordship, we have challenged
So
the
that
particular
2009 matter,
clause, like, Lordship, that whether the incumbent is required to have their own land, Lordship. That particular provision we have challenged.
2008. But see, if there is some illegality in the selection,
My lord.
the selection process will go.
My lord.
Definitely.
Then it will be either through press advertisement or in terms of the order of the court. There cannot be anything like that. The entire, now it is difficult to find out, to remove the set from the grain. The entire selection will go.
My lord, if there goes, my lord, then we can be accommodated or
How can you
regularized.
be accommodated? The 2009 judgment.
Lordship,
my
may I
lord,
kindly see the
my lord,
qualification, some of the petitioners, Lordship, who are not passed, my lord, class 7 also, class 6 also.
They are not to that extent. How will you go the 2009 order?
My lord, what my lordship has, my lord, come up with the 2009 order. Yes, my lord, definitely that is attained finality, my lord. But the issue
Will
is
you be
that,
able
my
to
lord,
twist and turn?
my lord,
Will you be able to twist and turn?
no, my lord, no, it is a not matter of, my lord, we cannot twist and turn this honorable court's order, my lord. It is very specific and clear, my lord. Only thing, my
So
lord,
they will participate in the process in terms of the guideline.
no, my lord, because why I am submitting, my lord, because the regarding that government is well aware, my lord.
That order of 2009 of
My
this court was
my
much before the order passed by the Honorable Division Bench in the apex court. Whatever the order, Kondorpo Kumar Das husband came in 2011 by
11.
the apex court. Much before that 2009 has been clarified. How will you overcome?
My lord, in that respect of the matter, my lord, my case, my lord, is slightly, my lord, in a different.
See, you
footing, my lord.
want some kind of benefit because you want regularization.
My lord.
And with regard to the regularization, already there is an order from the court with regard to Kopraja, right?
My lord.
With regard to Kopraja, passed an order.
My lord.
And that specifically directed that individually they will file an application. It will be considered in terms of the guidelines issued on 6th of January 2016. That notification of 6th of January 2016 has already been cancelled. A new notification has come.
The last notification, my lord, as per my knowledge is concerned, my lord, it is of 2021, my lord. And my lord, what has happened in my case is slightly in a different
Some
footing.
2018 notification came.
No, my lord, after that 18 certain notification has also been made.
Okay.
My lord, in the year 2019 and 21 also, my lord, those notifications are not brought on record, my lord. My lord, what I respectfully beg to submit before my lord is that, my lord, in our case, my lord, it is slightly different with the
Lordship,
Kokraj.
2019 and 2021, Lordship, my lord, it was annexed in the, my lord, that WPC number 8394, Lordship,
My
in my affidavit.
Now, my lord, in my case, my lord, the process.
Mr. Das, just a minute, we have here, already appointment of the respondent number 7 has been stayed.
Lordship.
So
So there is a further, there is a direction for further consideration, Lordship. Now I should be appointed because, Lordship, as per Lordship, that search sheet also, Lordship, it has been proved what I alleged in my writ petition, that has come true. Now because of the
where is your
element,
selection?
Lordship,
Where is your selection? Participated in the selection process?
yes, Lordship, I have participated in the selection process. Lordship, may I kindly see? Lordship, initially, Lordship, it was page 54, Lordship. Page 54. Lot number.
Mr.
Then,
Mia,
My lord, my lord,
even this order of the court,
my lord,
9th of October 2018,
my lord.
that was in which writ petition? Three eight two eight,
Yes, my lord.
your case only.
Yes, my lord.
That's very clear.
My lord.
The court specifically observed the claim of the petitioner may have some basis if it is established that their appointments were made through a valid process and in accordance with the provisions of the statute. Where is that statute by which you are appointed?
No, my lord, yes, my lord, that is the question, my lord, the government
When the
has,
court observed,
my lord.
that finding is still there,
No, my lord, that is
passed
the,
in October 2018.
my lord, that is the crux of my case, my lord. The government has said that we were appointed by the villagers of the, my lord, particular lots and villages. Now, my lord, on the day of our appointment, my lord, what were the statutes and the law governing at that relevant period of time? That, my lord, that law had been violated and we had been appointed, that has not yet been said in their affidavit, my lord. They are also silent regarding that issue, my lord. So therefore, my lord, as for the district of Dhubri,
Basically,
my lord,
Mr. Mia,
my lord,
these posts were not there. These civil posts were came later after the sanction, right?
my lord, that is correct.
So after the sanction by the government, everything was enquired. What will be the requirement of finance and whatever.
My lord.
Then after the government have sanctioned these posts, after the sanction, you wanted a regularization.
Yes, my
because
lord,
you worked
because
in honorarily, court have rejected in the interim. That interim order was set aside.
My lord.
Selection was held. Rightly, wrongly, that selection was held.
my lord,
Now, once selection is held and somebody is appointed,
my lord.
where will you be considered for regularization?
No, my lord, that's why their appointments were under challenge, my lord. Their appointments, my lord, during the pendency of the writ petition, my lord, they have made the appointment, my lord, without waiting for the final outcome of this. The deputy commissioner, my lord, was in a hurry, my lord, to make the appointment, my lord.
Anyway,
No, my lord, with all respect, what I am submitting, my lord.
we are not on that. Selection may be wrong.
My lord, but my lord, our rights, my lord, yes, my lord.
Court, after considering all aspects,
Yes, my lord.
allowed to proceed, right?
Yes, yes, yes,
Just
Milord.
election and to make appointment.
Yes, yes, subject to outcome, Milord.
Mr. Das,
Lordship, page 112, Lordship, may kindly see.
112
Lordship.
of your repetition.
That is a affidavit. That is a running case, Lordship. That is affidavit in reply.
Election, yes.
Page 112. Serial number, let's say 106. Application serial number 298, Azimuddin. He applied for lot number 13. Yes. Yes. Now, Lordship, although he has applied for lot number 13, Lordship, he has been selected against lot number 14. And that your Lordship will find from the search sheet. Lordship, I have filed a rejoinder affidavit, bringing on record, Lordship, the relevant portion of the search sheet that was filed on 19/1/2023. The running page is serial number, page number 145. Page 145. 17.14. During investigation, it is found that one selected candidate, namely Azimuddin, son of Nizar Rahman of Kharuabanda, applied for lot number 13, but was selected against lot number 14. In the interview sheet, Saibur Rahman, lead and ADC member of the selection board, had shown his name against lot number 14 by overwriting lot number 13 without making any initial. This is the finding of the Lordship, that search sheet, Lordship. And Lordship, all the other members of the selection committee, Lordship, except Atika Rahman Sultana, Saibur Rahman, then Lordship, they were under judicial custody. And lastly, on this honorable court by order that has interfered, after going through all the records, Lordship, has interfered his appointment. Lordship has already seen. In that said order, Lordship, it was also stated in paragraph 5. This court put a specific query upon the Land Council for a response number 2 to 6 as to whether the said respondents agreed to the opinion as stated in the search sheet. The Land Council, with all fairness, submitted that the official respondent do not differ with the opinion as stated in the said search sheet. Now, since the search sheet has stated that there is the overwriting and he applied for lot number 13, but he was shown to have been appointed under lot number 14. So the petitioner, despite his selection in lot number 13, he should be appointed now also. Because I have been waiting for my turn also since 2015 also. And Lordship, I have heard that Lordship, just 3 days back his appointment has been now interfered. And it is a contempt, Lordship. If they have not, if they have not cancelled the appointment of the response number 7, Lordship, in terms of the honorable court's order.
Mr. Henrik, these application forms are with whom? With the investigating agency or where?
My learned friend can say, investigation বস্তুটো করে হয় ডকুমেন্টস খিনি কাটা ইনভেস্টিগেশন না
whether
এটু কেন পায় 12 second calculation
application of the response number 7 was verified by whom?
It was investigated by the Siam Visual Cell. That is a Lordship, the rejoinder, Lordship. I have.
Can I listen for?
In the rejoinder affidavit, Lordship, I
I
have.
do not know whether the application of the response number 7 was verified or only basis of this chart they have submitted the search sheet. Whether on the basis of this particular chart they have submitted a search sheet or on the basis of
during
each of the applications of the petitioners or the
It has been
respondents.
stated that during investigation, it is found.
That's what.
They may have verified, Lordship.
Mr. Nath,
But
whether these records have been seized?
but some records have come, but I could not verify it. It is in my office. Kindly give me some time, Lord. I'll come back with the
We
record.
want to know that respondent number 7.
Yes, yes, my lord.
His application was for lot number 13 or lot number 14?
Lot number 14. I'll come up. The records are there. I'll verify.
As per this chart submitted by the
Verify and
petitioner,
come. Lodge.
his name is there in the lot number 13. But what he is pointing out that he has been appointed as lot number 14.
Lodge.
And this fact has also been clarified in the chart sheet.
Lodge.
So only thing is his original application,
Application.
whether it is under 13 or for 14.
14. Correct. Record. Some record has come. Otherwise, the private respondent possibly he is there. If it will be this to me.
Item number 3. 7. 8. 10, 11, 12. 11 now. Sorry. 11, 12, 13, 14.
Segregate course. Segregate course.
Pertains to appointment of Gaungura. The district of South Salmara, Mankachar. Mr. Nath, can you tell us what is the total number of Gaumburas that has been allotted for the South Salmara? Because earlier it was district Dhubri.
In fact, in the
Dhubri altogether, but it will be now bifurcated from Dhubri.
yes, creation code is 497. No.
Okay, South Salmara 82.
South Salmara 82. Yes, page 43.
Mankachar 70.
South Salmara, yes, Mankachar 70. This is writ petition 3828 2018. Page number 42 and 43.
The state government and the revenue and disaster management within bracket LR department by notification. This is 0501/2015. Introduced Gaungura systems. Gaungura system. The districts of Goalpara, Dhubri, Kachar, Kokrajhar, Goalpara, Dhubri, Kachar, Kokrajhar, Karimganj, Hailakandi, Bongaigaon, and Chirang. With effect from 01/01/2015.
Lord, I am sorry, my lord is disposing it.
Altogether creating 2419 numbers of new Gaungura lots, out of which total number of villages of 1091 numbers of villages of district Dhubri. 49 numbers of Gaombura lots were created.
497.
Next. The state government in the General Administration Department by notification dated 25/01/2016 for administrative expediency EXPE PI sanction formation of a new administrative district I South Salmara Mankacha district comprising the whole area of South Salmara subdivision except area of Fakirganj Jilla Parishad constituency and except Bir Singh BIRSNGH Jarwa JRWA block and Jamadar Hat block development block with headquarters at Hatchingimari. After such bifurcation, after such new constitution of the South Almara and Mankacha district from the Artsoil district Dhubri on 25/01/2016. In terms of say notification dated 05/01/2015, the Deputy Commissioner Dhubri in its land settlement section out of 497 lots, Gaombura newly created on 05/01/2015 as noted above, allotted 82 numbers of Gaombura lots 1 to 4 for the South Salmara revenue circle and 70 numbers of Gaombura lots of Mankacha revenue circle. Thereby notification. After such creation of newly creation of South Salmara Mankacha district by notification dated 25/01/2016. Those 82 numbers of Gaombura lots of South Salmara and 70 numbers of lots of Gaombura came under the was brought under the jurisdiction of the Deputy Commissioner South Salmara from Mankacha. Altogether, 152. And the remaining (345) number of Gaombura lots out of 497 Gaombura lots, 40 purpose of district created on 05/01/2015 remain under the jurisdiction of the Deputy Commissioner. প্রথম তো ইস্যু রিলেটেড very neat. Some of the petitions are related to claiming regularization of their services as Gaunbura who were appointed in the year 2005 by the local public and others so as to help the revenue administration prior to creation of Gaunbura lots. In South Chalmara and Mankasa revenue circles, Deputy Commissioner. In preview, all these petitions. Shall be clubbed together, considering the fact that a similar issue relating to appointment slash regulation of this is one. Second of two. Except item number 11. Except item number 11. Bill 497 billion. Plus actually. By order it is 0601. Super Deputy Commissioner to pay 90 numbers of Gaunbura lots were allocated. Every revenue service to 60 numbers of Gaunbura lots development revenue circle. 55 numbers of Gaunbura lots. Abovani revenue circle. 90 numbers of Gaunbura lots. Vilasapura revenue circle. And 50 numbers of after bifurcation, South Chalmara revenue circle of the Mankasa revenue circle after the data review. South Chalmara altogether 2, 4, 5 numbers of Gaunbura lots. Out of the total 497 initially. Is to count 512%. These petitions how it relates to after a case, Deliberation of the matter. It is seen that with regard to honorary Gangura serving in South Salmara. Cycle file present the district of Dhubri for consideration of their adoption as Gangura. The court 1906-2009, WPC number 1320, public 2009. San Mia, CHAND, MIA, UMDAR, and 24 and others versus State of Assam, the Revenue and DM, LR Department versus 3 others. Directed the respondents, the Revenue Department says, as well as the Deputy Commissioner of Arthur District Dhubri, to fill up the post of Gamburas in different villages of Dhubri district in terms of the government guidelines issued for that purpose and following the due process of law, as and when the authority sanctioned any post and decides to fill up such post. With the further observation that the petitioners shall also be considered if they apply for those posts and necessary weightage for past experience shall be given, if permissible under the law.
Milord, sorry, Milord.
The said observation of the court dated 1906-2009 was passed in WPC number 1320 of 2009. By a flux of time has attained us finally as the same was not challenged before any other higher school. The respondents in the revenue and the system and the by filing additional affidavit shall apprise the board as to whether it has taken any decision to grant weightage to any such applicant for the post of Gaonpura, considering their past services as honorary Gaonpura, different villages, serving in different villages prior to creation of post of Gaonpuras in the district of Dhubri, including Salman and Mankacha. District. And to regularize the services of any such honorary Gaonpuras serving in the district of those two districts. Order. The said additional affidavit to be filed by the respondents in the revenue and EM department put in the catalog. Shall also apprise as to whether Such affidavits shall be filed by the respondent such and such on or before. When
Lordship may give us 3 weeks time now. After in the first week of September.
the
जी after no.
give us a date.
On
11.
No, you'll be filing your affidavit by 31st of August. 38th of August, I think so. That will be sufficient.
31st. Lordship.
Okay, 31st of August.
Lordship.
Serving a copy of the council for the
Malad.
petitioners. Obtaining necessary acknowledgement, petitioners as well as to the council for the other respondents. Obtaining necessary acknowledgement from them. Thereafter, petitioners shall file their reply if so advised on or before 12th of September without fail. Placed on 14th of September for further consideration.
My lord, the letter my lord mentioned me in the page 44 of my writ petition me. That letter may also be produced me.
Mr. Nath,
Malad.
3828 me.
page number 45. You come to place 44.
44. Yes, 44.
That's a letter from some minister
Yes.
being agreed with the letter of that decision of
Lordship.
6th of January 2016
Lordship.
regarding the filling up the post of Gaumburas.
Malad.
Pursuant to that, the letter was forwarded by the additional deputy commissioner, wherein there is a mention of a letter of same date, 7th March, but the issue numbers are different. That issue number is 236, whereas the page letter at page number 44 is of 237.
236 and 37, 2 letters.
It will be in the same file. Find out what is there and let us know. The petitioners in this petition are only hoping that their services should be regularized.
No, Malad,
That will be taken decision in
Malad, when
later stage. We are not saying
the
anything on that.
when the matters were moved, Malad, Lordship, I will take the instruction. When the matters were moved, Malad, we took the instruction that applications were filed from there and those were forwarded to the authority without doing anything. Malad, whenever an application is filed to the DC, he used to just forward it to the government. They have prayed for regularization. There is no post. Lordship has seen creation of post in 2015. They were not against any post.
But
So
thing
we'll
is this,
respond.
the
We'll
stand
respond.
taken in the affidavits are also not very specific.
Malad,
That in both the writ petitions, if you see both the
correct.
affidavits filed
Correct.
in this, and where you are required to file in affidavits in other writ petitions where you were silent.
Correct.
Because you have not filed affidavits
Correct.
in most of the cases.
Malad, correct, Malad. Malad, in the yes, in the first case, Malad, we will file a detailed affidavit indicating everything. And Lordship, I would pray for a liberty that affidavit will rely in all the cases because issue is same.
But what we found that MSGB Bora, which is the secretary, joint secretary of the department, filed
Revenue.
that first affidavit in the first case.
Revenue.
It's not very clear.
Malad will come out.
So in item number 14, there is a stay order also. That may be.
Item number 14, response number 7.
No, there is a stay order also. That has been continuing also. I mean, item number 14, Nazrul Islam says, no appointment has been made.
will come.
In that particular lot, no appointment has been made, Lordship, because of the stay order.
In fact, my lord, this type of stay, petitioner is not getting anything, my lord. Otherwise, the harassment is
Petitioner
caused.
is continuing, Lordship. The stay order is continuing from 2018.
Petitioner is. Since order is there, my lord.
And
Order to ask continue.
that should be reflected because in item number 4, it has not been reflected, and that is why court is not inclined to extend the stay order.
14. Yeah. 14 or right?
14 or interim.
Our Jogya says, Jogya says, এখন মেইন এফিডেভিট বনাইলাম মেইনখন বনাইলাম এটা রিলাই কৰি দিম ইস্যু যদি যিখিনি আছে লং টাইম পেপাৰ আমাৰ কথাখিনি সোমাইলে আৰু তোমাৰ আহিলে ডিভিজন আছে.
On last few occasions, Lordship, there some orders have been passed that wherever there is a stay order, that will continue. So there may not be an individual order also, but in item number 14, Lordship, that stay has been continuing from 2000.
Your case in this particular petition,
Lordship.
সিহঁতে ৰিপ্লাই দিব 12/9 আৰু আমাৰ আহিব 14/9.
January 2020, there is no stay order. If you want, you kindly check.
এখানে আমি নোট কৰি থব.
But Lordship,
There is nothing.
stay order has been extended time to time, Lordship. On every occasion.
There was no stay orders. I will tell you. The first stay order was of.
First stay order of 4/9/2019.
Then on 29/11/2019, there was no stay order.
That was fixed along with 2 other petitions.
There was no stay order because it was very clear.
Okay. Then 12/5/2022 again.
28th of January 2020, there was no stay order. On 25th of February 2020, there was no stay order. On 28th of November 2020, there is no stay order. On 10th of August 2021, there was no stay order.
12/5/2020, that interim order was continued, extended also. Because of the
Then-
losses, because these
Then
matters have been tagged.
23rd of November 2022, interim order pastorate will continue till the next returnable date.
Yeah.
Then again on 31st of May 2023, there was no stay order. And the order of 28/6/2023, interim order passed earlier shall continue till the next date. Where is the interim order in your case? Because there was no stay order on 31st of May 2023.
In that case, Lordship may kindly segregate these 2 matters because these are 2 individual cases wherein Lordship I have challenged the selection and appointment. Lordship may kindly segregate because these
Which
matters
two
are
items?
these matters are tagged together along with these bunch of writ petitions.
Which 2 writ petitions?
12 and 14, Lordship. And Lordship may kindly extend the interim order because
14. Check to it over. File application.
yes,
File
I'll file.
application will come.
And Lordship, in item number 12, Lordship, they were supposed to
12 and 14. Yes. Follow me. They are from Dhubri or South Salmara?
South Salmara. These 2 matters may be segregated, Lordship.
In these 2 matters, 2 matter relates to.
And in item number 12, Lordship, in terms of the earlier order,
Gaumburas in the South Salmara Mankachar district. But challenge here is with regard to the appointment of the private respondent by the Deputy Commissioner of Salmara. But anyway, we'll see.
in item number 12, also they are supposed to cancel the appointment in terms of the earlier order.
Application will consider.
কি order আছে আগত বড় করে তো order দিছিল
Stay করা বলি, cancel করা বলি, sir. In the interest of stage the selection and appointment.
ওরে বাপ রে দাও বলা দেব
Stay করছে।
taking into account the above and more particularly decision One again. This court stays the selection and stay. Okay.
अरे 12-14 to segregate করছে না এই স্টেপ কন্টিনিউ আছে এটা করেছে এই একেলগে সব বিলাক অর্ডার পাস কৰি দিয়ে একেলগে গোটেইবিলাক কেছত
পাবলৈ হ'ল মই কৈ আছো
কিমান গ'ল আইটেম নাম্বাৰ
এফআইআর যে নাম আছে আতিকুর
Yes, Mr. Gultami.
Lordship, Lordship has perhaps gone to the order, my Lordship, page 17, my Lord. Everything has been reflected, my Lord, how he is involved in this case. My Lord. He is, my Lord, involved in, my Lord, selling of fake gold biscuits, my Lord. And the petitioner gave money, and in turn he hand over a fake gold biscuit. And when he tried to, my Lord, sell it, my Lord, then he came to know that it was fake, my Lord. And 3 persons are there, my Lord. One of them is arrested. He has divulged that, my Lord, 3 persons are there along with the petitioner, my Lord. And account detail also reveal, my Lord, that money has been transferred, my Lord. Two persons are on the run, my Lord. They could not. Lordship, page 17, your Lordship will kindly see, my Lord.
Yes, what is the new ground, Mr.
There is no
Bhushan?
new ground.
My lord, merely on presumption, my lord, police is charging, my lord. Lordship, kindly see the FIR, my lord. FIR, Lordship, he is from Gulagat, my lord, and we are from, my lord, Tezpur. And he, my lord, made transaction with, my lord, one Atibur. His Lordship in the FIR itself, my lord. I am not named in the FIR, no way connected, my lord. And he is a, my lord, he is suffering from ailment, my lord. He is ready to cooperate, my lord. He will cooperate. And one person is arrested, my lord, already. My learned friend said, my lord. I think he is really.
Again,
And in similar cases, your lordship granted bail in 439.
So not in 438.
Here,
So
my lord, no way.
consider 439
Lordship.
and go, doesn't matter.
He is not named in the FIR. Transaction made with a Atigur. He, my lord, directly implicated, my lord. And he is from Gulagat and transaction made in Tezpur. He knows everything, my lord. He is also, my lord, directly involved. The informant is also, my lord, directly involved. And he should also face the consequences of loss, my lord. I am ready to cooperate, my lord, at any terms and condition, my lord.
That will open the floodgate.
He's a
Many are on the run.
lost. In the FIR, my lord, one Atikur Rahman is directly, my lord, he made transaction with his account. Account is also not in the name of, my lord, the petitioner, my lord, Iqbal Hussain.
Lordship will
So
find
merely
from
on
the
suspect, my lord.
one of
even,
his
my lord,
associate, my lord, the
40
Lordship will also find, my lord, that he has
41
named this Iqbal and Atikur, both persons, my lord.
41 notice has not been issued, my lord. Which is now in the later judgment, the Honorable Supreme Court, my lord, directed to, my lord, mandatorily comply the 41A notice, my lord. He's a local boy, my lord, there is no chance of appointing. And most of the, my lord, most of the accused, my lord, involved in this track, my lord, already surrendered.
Landed trade knows, my lord. Most of the, my lord, men involved in this kind of racket, my lord.
Only he is left.
No, I am no involved, my lord. Merely on presumption, my lord. The police also on presumption. FIR is of March, my lord, 2003. Even, my lord, transaction made in January, FIR filed in the March.
Also, may also kindly see the statement of Patpal Ali, my lord, what he says, my lord. Last flag. He full biscuit লইছে এবার।
Informant, my lord, in the allegation also, my lord, is not bona fide purchaser, that he has been seated. Offense, my lord, 420 and 406. 406, my lord, in this case, does not arise, my lord. He has not entrusted me.
This is the petitioner, my lord, who got the gold biscuit from another accused who is arrested, my lord. And thereafter, he sold it to the my lord, informant.
Mr. Ali also appearing for the petition. And Mr. MP Goswami and direction of particular. The petitioner, namely Iqbal Hussain, has filed this application under section 438 CRPC, seeking pre-arrest bail in Tezpur Police Station case number 279/2023, registered under sections 420/406 IPC corresponding to GR case number 327 of 2022. The petitioner earlier preferred AB number 1280 of 2023. Seeking pre-arrest bail inside Jasper case number 279 of 2023. And on perusal of the case diary, the court by order dated 24/05/2023 rejected the prayer of the petitioner pertaining to his pre-arrest bail and decided Jasper case. This is petitioner's second pre-arrest bail application inside Jasper case number such and such. The case there reveals that the petitioner impersonated himself as Shankar Dev Nath, SANKAR, Dev Nath, and supplied gold biscuits to the informant. And those gold biscuits later found to be fake gold biscuits. It is seen from the case there how the petitioner procured the gold biscuits from the arrested accused persons and is to sell to his customers, impersonating himself as Shankar Dev Nath. Case study also reveals that as per the account given by the petitioner to the informant who purchased those gold biscuits from the petitioner, the said informant in the given account of the petitioner deposited money in three phases. Deposit money in phase manner. And those were withdrawn by the petitioner immediately. Case diary reveals that the said bank account given to the informant of the case after due verification found that of the petitioner. The case diary reveals it is also seen from the case diary that police visited his residence. Police visited the residence of the petitioner, but he evaded the arrest and fled away. Case that reveals the involvement of the petitioner in the alleged crime of distribution and sale of fake gold characters and as well as fake gold items. Considering such materials in the case that he reported the defense to the case to grant pre-arrest bail to the petitioner inside this case number such and such.
Obliged.
My please, your lordship, I paid for adjournment in the morning.
On the priority petition. Party.
Lordship, I'm for the respondent, Central Bank.
Matter be
Obliged.
the petitioner has already dismissed the service. And a disciplinary proceeding initiated by the respondent bank. It has been affirmed by the appellate authority. Next.
Much obliged.
Lordship, here we have filed our affidavit in respect of item number 17, 20, 21 and 22, Lordship. 17, 21 and 22, we have filed our affidavit. And item 17, 21 and 22, we have filed. And in respect of 18, 19 and 20, we have sent it for vetting, Lordship. So we will be filing our affidavit in respect of 18, 19 and 20.
What about 23, 24?
23 is not in the series, Lordship.
That's different.
17 to 22, Lordship.
We have filed in
File in 17, 21 and 22. 6807 of-
file.
Lordship.
When did you file? When did you file your affidavit?
Recently, Lordship. Perhaps it is not on record, Lordship.
Huh?
Perhaps it is not on record, I will. No.
When did you file?
We have received a copy yesterday.
Yesterday, day before yesterday. My Lord colleague Mr. P.K. Bora filed it on item number 17, 21 and 22. And this 20, 18, 19 and 20, we have sent it for vetting, Lordship. Next week.
It is submitted to the respondent authorities in the education department have submitted, have filed their affidavits in WPT number 17, 21 and 24. Serving copies of the same in the council for the petitions which have been accepted. Other than Mr. Ken Sharma, Study Council, Department of School Education. Elementary submitted. The affidavits for item number 1892 have already been forwarded for vetting. In view of the above, these matters on 12th of September. And in the meanwhile, the petitioners shall file their reply if any to the affidavits of the respondents.
Much.
Lordship, next day.
12th of September. 12.
I appear on behalf of Mr. Ukema in this matter, Lordship. Lordship, today there is some difficulty on his part, Lordship.
Yes, Mr. Woman.
Okay, Lordship. Can it be taken up next week?
Just a minute. Let's see, what's the hurry? What's your prayer here?
Lordship, it relates to the date of effect of the grant of 3 additional increments upon acquiring PhD degree, Lordship. And the respondents, Lordship, in the last page 51, Lordship, will find that they had effected it with effect from 2010, Lordship, whereas 2011, Lordship, in the first matter, whereas we have acquired the degree earlier, Lordship. And they had directed the principal to calculate the amount that was paid in excess to us, Lordship, and then they would also recover that amount, Lordship, that was being stated in that communication. Subsequently, Lordship had protected us, Lordship, and the excess amount that was to be recovered was not to be recovered, Lordship. So that is the position till date, Lordship.
What is the stand, Mr. Govind?
Lordship, our stand is, Lordship, they have acquired the Lordship, the degree on Lordship 1/7/2011, Lordship. And the teachers who have acquired MPhil and PhD degree, etc., on or after 1/1/2006 to 1/1/2008 have been allowed PhD MPhil in increment with effect from 1/9/2008 under 6th UGC pay structure as per their stage of service as rendered for, and for those teachers acquiring after 1/9/2008, they have been allowed from the date of acquiring MPhil PhD degree on merit on or immediate next date of increment rendered in the same stage, Lordship.
Where is that? Is there any notification or any memorandum or something like that?
Lordship, there is a OM, Lordship. As per government OM number AHE 396 of 2010/2022 dated 27/4/2012.
So from which date you have given that effect?
Lordship, they had already earlier given it with effect from the date I acquired the PhD degree, Lordship, but then subsequently they sought for recovery, Lordship, giving it with effect from 25/2019, Lordship. The Lordship with effect from 1/7/2011. We acquired it on, it was given with effect from 7/9/2007. Subsequently, that date was sought to be
1/7/2011.
reassessed. Otherwise, Lordship, while granting us the interim or protection, Lordship, the principal of the college was directed to calculate the amount that was to be recovered from us. That calculation has not been got on record, Lordship. That if it is got on record, Lordship, that will be helpful for us.
Yes, Mr. Govind, what is the case about?
Lordship, for principal, Lordship, I'm not appearing for the principal. Principal party position.
No, at least from the Director of Higher Education, kindly tell us.
Lordship, as per the OM, Lordship, we are giving it from the date of acquiring the degree, Lordship. And Lordship, since he has acquired it in 2011, Lordship, that's why we have calculated the date as 1/7/2011, Lordship. By department order number. So and so dated 5/12/2012, Lordship.
You have issued from 11.
Yes, Lordship.
Because the petitioner required his PhD in terms of this notification. Right?
Yes.
Exercise 6.
Annexure 6 is the PhD degree date of acquiring it.
Not that one. When did you receive, when did the university notify?
Notified. It was
2012, so 7. University also is the PhD, the higher education department.
See, when did the university notify for the PhD that you have obtained PhD? There has to be a meeting of the university. That meeting will approve.
Yes,
Where is that?
That is not there, Lordship. It will be an and not been annexed, Lordship.
Then how the department could come to know? How did the department came to know?
Maybe it has placed before the department.
Lordship, at paragraph 4, it has been stated, Lordship. He, second line, Lordship. He was also conferred with the Doctorate of Philosophy, hearing after referred to a PhD by the Guwahati University by notification bearing number so and so dated 7/9/2007.
Where is that?
Not there, Lordship.
It's at annexure 6, page 32. It starts at page 32. And the date, Lordship will find at page 33. His name appears in page 33, the second one, Lordship.
This notification came into force when?
It's given. Resolution was taken on 18/8/2007, Lordship. It's at page 32.
Yes. When is the office memorandum came into force?
2012, Lordship. 2000.
What is the date of giving effect?
Once, Lordship, 27/4/2012, 1/9/2008.
Mr. Govindu, read page, para 9 of page 42.
Yes, Lordship. However, teachers in service who have already been awarded PhD by the time of coming into force of this regulation or having been enrolled for PhD have already undergone coursework as well as evaluation, if any, and only notification in regard to the award of PhD is awaited, shall also be entitled to the award of 3 non-compounded increments, even if the university awarding such PhD has not yet been notified by the UGC as having complied with the process prescribed by the Commission.
Come to page number 12 and 13. Where is the order for recovery?
Lordship, sir, page 51, Lordship.
Last page, Lordship.
5-1.
Yes, Lordship,
Yes,
last page.
Reading the whole Lordship. In terms of government instructions contained in OM number so and so dated 27/4/2012 and in supersession of earlier order issued by number so and so dated 5/12/2012, the 3 non-compounded advance increments are hereby allowed to Dr. Vibhuti Chaudhary, librarian of LCB College, Maligaon, Kamrup, with effect from 1/9/2008, raising his pay at rupees 34,760, which DNI 17/2009 in the scale of pay of rupees 15600 to 39100 plus AGP 8,000 for acquiring PhD degree on 7/9/2007 instead of rupees 50,580 with effect from 1/7/2011 in the scale of pay of rupees 37,400 to 6,700 plus AGP 9,000 with DNI on 1/7/2012. The principal LCB College Maligaon Kamrup is hereby directed to calculate the amount payable to the teacher concerned due to advancement of the date of advance increment with effect from 1/9/2008 from 1/7/2011, along with calculation of overdrawal of salaries resulted due to allowing of
advance increment with effect from 1/7/2011 and take necessary steps for adjustment, refund of the excess royal amount to the government exchequer through treasury challan. That was the communication made.
Mr. Upamenyu,
Yes, sir.
the petitioner is entitled for such 3 increments since when? In terms of that notification?
Date of expiry.
Lordship, 1/7/2011, Lordship.
Tell us.
Lordship,
Why
there
you
was,
have asked for recovery? Where is the illegality?
Lordship, there was a gap of almost 3.5 years, Lordship.
No,
Lordship,
3.5 years for what?
Lordship, Lordship, at page, Lordship, the affidavit in opposition that we have filed, Lordship, at para 7, Lordship. Lordship, that in regard to the paragraph 4, the answering deponent states that the petitioner was conferred the PhD degree by the Guwahati University by notification number so and so dated 7/9/2007, and also it is a fact that he was granted the associate scale after acquiring of PhD degree with effect from 11/3/2011 at rupees 37,400 to 67,000 plus AGP 9,000. That is after a gap of about 3.5 years, Lordship. Lordship,
So
that-
what? You have conferred associate scale
yes, sir.
with effect from 11/3/2011.
Yes, Lord.
And for associate professor, it's a mandatory that the incumbent must have PhD.
Yes, sir.
That's a different procedure. At the same time, your office memorandum is saying that those who have acquired PhD degree during service tenure, they will get 3 increments.
Yes, Lord.
And that will have effect from
Lordship, the date
1st of August 1999. Is not it? 1st of September 2008.
2008, Lordship.
So,
Or from the date of acquiring such degree. Lordship.
this is why I've been telling you. There are 10 you have seen,
Yes.
9 you have seen from the date of acquiring it.
Yes, Lord.
Where is the illegality here? Why you are trying to recover that amount? What is the reason? Yes, Mr. Gogoi.
Lordship, 10, Lordship, of page 42, Lordship.
Hmm.
The teacher in service awarded PhD PhD under the earlier scheme / regulation on or after 1/1/2006, and by the time of coming into force of this regulation shall be entitled to get 3 non-compounded increments if such PhD is in a relevant discipline of employment, and 1 advance increment in case of teacher in service who have been awarded MPhil degree.
So, that is why, tell us, where is the difficulty? This person, this petitioner has obtained his PhD, right?
On 1/9/2008. No.
Mr. Upamanu,
Yes, Lordship.
come to page number 32.
Yes, Lordship.
Here you see the page 32.
33.
We are not on 33 now.
32.
Come to
Yes.
32.
Yes, Lordship.
The Executive Council's resolution was of 18th of August 2007,
Yes, Lordship.
right?
Yes.
Now, here the name of the petitioner at page number 33, serial number 11.
Yes, Lordship.
And what was his relevant discipline? Arts and library and information science. So there was nothing wrong procuring that PhD degree from any other, because it has to be a relevant discipline.
Yes.
So it is under the same discipline he has procured it. He procured it on 8th of August 2007. Now, as per this memorandum, clause 10.
Yes.
PhD degree was awarded after 1/1/2006
Yes, Lordship.
and before coming into the force of this office memorandum, which is with effect from 1/9/2008. The petitioner, in terms of clause 10, are entitled to get 3 non-compounded increments.
If we,
So, the other two constraints are if such PhD is in relevant discipline or employment. He got it because this PhD in the relevant discipline, library is there and employment, and then he was a librarian. And 1 advance increment in case of teachers in service who have been awarded MPhil. This will not be applicable to the petition. Then if he is entitled for such increment, 3 advance increments, where is the illegality for recovery? Why do you want to recover it? What is the reason for recovery? Where is the illegality?
At page 51, Lordship, there is.
In the affidavit, it's not clear.
Yes, Lordship.
What is there in the affidavit?
Page 51 also, there is nothing to that effect.
That is also wrong. Para 7, he was conferred degree on 2008, 18/8/2017. Okay, thereafter notification was published probably. So here the director has admitted that it was wrongly calculated from 1/7/2011. It should have been from 1st of September 2008. Then why this order was passed? Can you tell us? At page 51.
The department has not withdrawn the benefits of free payment as contended by the petitioner. The date of effect of with effect
You got it or not?
Lordship, at page, Lordship, at para 16 of our affidavit, Lordship, it is stated that the department has not withdrawn the benefit of free non-compounded advance increment as contended by the petitioner. As the contrary, the date of effect of the benefit of advance increment earlier granted with effect from 1/7/2011 is advanced with effect from 1/9/2008 as per UGC regulation dated 36/2010, and clause 10 of the government OM number so and so dated 27/4/2012, grant of benefit of advance increment from the due date on 1/9/2008 by advancement of the same from the earlier date 1/7/2011 cannot be termed as arbitrary.
So,
Lordship, in fact, that was the statement made in the affidavit, Lordship, but from perusal of page 51, Lordship, that does not transpire, Lordship, per se. And
Mr. Gogoi, we are asking both the petitioner and the standing counsel. The affidavit also vague.
See, I have gone through it, Lordship. It is
No,
not
it's
proper-
nothing. It's
not-
very simple thing.
not properly
Basically,
answered.
it's very simple.
Lordship,
The petitioner acquired his PhD on 18th of August 2007. Probably the notification was issued later.
On
That
12th,
is why the notification will come. There has to be a notification.
Now, regarding
So,
PhD, Lordship.
as you know, in the university, there will be
Lordship.
notification. This is the order. In fact, this is the notification. I don't know why it has not been considered.
Lordship, it is,
It should have been 18th of August 2007.
Lordship, it
But,
is as per the EC's regulation 18th of August 2007, Lordship.
But notification is published on 7th of September.
Lordship.
So it is 17th, let us assume it's 7th of September
Lordship.
2007. Now, in terms of this office memorandum,
Lordship.
at clause 10,
Lordship.
he is entitled for 3 increments.
Lordship.
Now, 3 increments from when? On completion of his
PhD, Lordship.
right?
Lordship.
But this increment is given effect from 1st of September 2008.
8, Lordship.
But whether the petitioner was given increment from 2011.
11, Lordship.
17/2011.
Lordship.
This order of the director
Lordship.
is correct,
Lordship.
but the explanation is not proper.
Lordship. That is the
Right. So
Lordship.
yes, the petitioner should have been given the benefit from
2000.
1st of September
2008
2008
Lordship.
instead of 1st
Instead
of
of
September
2011
2011.
Lordship.
So
And Lordship even
whatever is there, you have to recover.
Lordship.
Why that recover? The reason is
Lordship.
2010 ROP was there.
Lordship.
Pay was revised.
Lordship.
UGC's pay scale was there in 2010.
Lordship. Lordship.
Scale was revised.
Lordship.
But in 2008,
Lordship.
it was the earlier pay scale.
Lordship. 19 as per 1998.
So that pay scale,
1990.
that 3 increments should have been assessed in the earlier pay
On the
scale.
basis of that pay scale, Lordship.
That explanation is
Lordship.
not there in the
In the
affidavit.
event, Lordship, affidavit also not explain that part, Lordship.
That is why the calculation has to be made
Lordship.
considering the increments in terms of
Lordship.
at that point
Even
of
Lordship,
time.
after calculating everything, Lordship, the petitioner, I think, Lordship, the petitioner need not to return anything because he also get the increment from 2010, Lordship. 2011 onwards also, Lordship.
No.
If,
Because in the earlier pay scale, the amount would have been different.
Lordship.
By the time in the 2011, when it was calculated,
Lordship.
it was under the enhanced scale. So
Even,
increment is also different.
even Lordship, 2011 also, he will get the three advance increment.
But it will be the higher scale.
It will be higher. Higher.
That's the difference.
Lord, that is the difference, Lordship.
No, my lord, what my friend is saying that 2011 also I am entitled because they
You are
have given,
entitled from 1/9/2008.
no, my lord, they have given me
From 1/7/2011.
11.
But you are entitled from
I
1/9/2008.
was entitled. My lord is correct. The 2008 scale, if they had given me, it would have been a lower scale. What they did was, my lord,
Lordship be huge.
what they did was, my lord, whatever was given not to this lady, others, my lord, they took it back. And then they issued this fresh order, giving it 3 increments from. Now the ratio here is, my lord, we were teaching in college. Person similarly situated with me, same my friend, same day joined. I did it in 2008. He comes and does his MPhil in 2011. So, my lord, MPhil or PhD, I did it earlier. I'm at a lower stage. He does it subsequently. He gets a higher scale. No. What they have done.
Should have done belated
That's it. That's it, my lord. That's what is happening. That's why what they did was.
Everywhere that was the
That's why what they did was, my lord, they took it back and then you. My lord, let my friend have those instructions.
Have we challenged this 2012 notification? That is not under challenge.
Lordship. That
2012.
Not under challenge. Clause 10 is not under
Lordship.
challenge.
Lordship. এখন দাদা 2010 2010 over 12 is 51 over just 51 over
41.
What happened when these increments were given?
Lordship.
The person who is to calculate it.
Lordship.
Right?
Lordship.
Without considering
Lordship.
effect. What was the reason for giving it from 1st of July 2011?
Lordship.
Not this way, not that way.
Lordship.
Why 1/7/2011?
Lordship. That is the
What
reason.
was the reason for 1/7/2011?
That is the reason we cannot explain, Lordship.
That you cannot explain.
Lordship.
That they will explain.
Lordship, we cannot explain.
That table and the file will explain.
Lordship.
Right.
Lordship.
There was no reason for 1/7.
Lordship.
Either is from the date of notification
Lordship.
or from the date of 2012.
12 Lordship.
Either this way or where
Why
from this
midway
1/7/2011?
Lordship.
Middle way,
Lordship.
right?
Lordship. I got it. I got it.
Why 1/7/11?
Our question curious.
We all know, right?
Amala, there are some things which we cannot.
We'll able not to say, but reason is why 1/7/2011? You have obtained your PhD in September
And my lord,
2000.
in the first case, that Eli Burua, next case, my lord, they have themselves said that she would be entitled to stepping up because another person has got it. They are giving that stepping up also.
See, Captain, if it is given in between the pay scale has to, in between the revised UGC scale. So those who have done it, who has obtained their PhD after the giving effect of the revised UGC scale.
After
they will
2010
get a-
also.
Definitely they will get a better.
Better pay.
But at one point of time, it is merged.
Lordship.
It will be merged. Next time it will be merged.
It will be merged.
It will be merged. It will be merged. It cannot remain as a separate pay also.
Why this 17/2011 for this particular? petition?
But can I make one submission? Today was tied up with something.
I understand.
My lord will have this matters on Thursday or Tuesday next month. My lord will keep it parted so that my lord it matter can get some importance.
Next Tuesday we will be celebrating our
Oh, my lord, sorry. Thursday, next Thursday. Next, sorry, my lord. The second time I'm making this one. In court number 6, I just made this prayer. দেখুন না, এটা কি মানে
Mr. Subramanian, yes, since we are handling that case, find out why this 17/2000, where from they got this date. Every file here, you will have a different date.
Yes.
Why? The reason. Find out. It's not the director.
Lordship.
It's the concern.
Sir will be Lordship. It will never come.
You know the meaning London, right?
Lordship.
That's the person who is doing London will know, or she will know.
Difficult to bring it on record.
That you have to bring it out. That 17/2011 was
Can I
wrong.
Lordship will call explanation from the authority. Lordship.
That still has to be.
Lordship. Lordship.
Notification is of 2000.
Lordship. Lordship.
Giving effect is of 19/2000.
They cannot. Lordship.
Suddenly one date 17.
Even Lordship. Notification.
Well, these instructions, well, I'm not dreaming talking about dreaming. My request one.
Yes, Mr. Bonnie.
May it please your lordship. One of this writ petition is for direction to the authorities to make payment of regular pension as well as leave encashment and death come retirement.
Not given to you
gratuity.
till date.
My lordship.
Not given to you.
No, the reason is on the interpretation of Rule 21 of the Assam Services Pension Rules 1969. May I briefly indicate a few dates which would be relevant?
Just a minute. Just. Yes, you are mentioning which rules?
I'm referring to, my lord, Rule 21
of the pension rules.
Of the pension rules, my lord. Before that, the basic dates may be relevant, my lord. 3 or 4 dates, it might be relevant.
Yes.
May I read 21? The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to government, if in a departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that A, such departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall, after the final retirement of the officer, be deemed to be a proceeding under this rule and shall be continued
and concluded by the authority by which it was commenced in the same manner as if the officer had continued in service. Explanation. The continuation of the proceeding after final retirement of the officer shall be automatic under sub-rule A of Rule 21, and no fresh decision of the governor and or the appointing authority nor any show cause notice to the person concerned shall be necessary. The powers under Rule 21 shall be exercisable not only in case of causing pecuniary loss to government, but also in all other cases. B. Such departmental proceeding, if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall not be instituted save with the sanction of the Governor of Assam. 2. Shall not be in respect of any event which took place more than 4 years before such institution. It is Rule 21B, Roman 2, where my case starts.
Yes.
Now, for the appreciation of institution and 4 years, may I invite my Lord's attention to Rule 21 D, second part, the other part, the other page. The explanation to the rule. A departmental proceeding shall be deemed to be instituted on the date on which the statement of charges is issued to the officer or the pensioner, or if the officer has been placed under suspension from an earlier date on such date, and a judicial proceeding shall be deemed to be instituted in the case of a criminal proceeding on the date on which the complaint or the report of the police officer on which the magistrate take cognizance is made, and in case of a civil proceeding, the date of presentation of the plaint in the court. My lordships, so far as 21C is concerned, it talks about judicial proceeding. 21B2 is concerned, it talks about departmental proceeding. Just for correlating the.
Yes.
May I read also 21C?
Yes, please.
No such judicial proceeding, if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall be instituted in respect of a cause of action which arose or an event which took place more than 4 years before such institution. Basically, I need to address this honorable court as to when a proceeding is instituted, if it is a judicial proceeding. Now, if I invite again, a judicial proceeding shall be deemed to be instituted in the case of a criminal proceeding. We are on a criminal proceeding now. On the date on which the complaint or the report of the police officer on which the magistrate takes cognizance is made. So we have two parts, my lord, if I may respectfully submit. One is a complaint and the other is a report of a police officer.
The date is fixed, the date when the magistrate take cognizance.
It may come from two streams. It may be an ejahar, therefore it comes under police report or a complaint case. On the facts of the case, the admitted position is the alleged incident is of 1999. The date of the ejahar is 2nd of September 2002. My retirement date is 28th of February 2018. And the cognizance is 31st of March 2012. If the cognizance is 31st of March 2012, then by application of 21D, I mean this departmental proceeding explanation part, this is beyond 4 years because the ejahar and the incident was 99 and the cognizance of 12, my retirement in 18.
But he was in service.
We're coming to that.
But he was in service. So the 4 years won't count. After retirement, the 4 years.
Yes, correct.
There is a judgment.
The judgment.
In this regard. That scam, you know.
Yes, Lordship.
Veterinary department. Veterinary department scam. When you were arrested. What was
Division bench judgment.
Huh?
Division bench.
No, what was the name? There's a scam there. What was his name?
Ukhil Gogoi.
No.
This is also a scam, you know, the greenhouse scam.
Some Bora. You remember? Either veterinary or in agriculture, I forgot some department.
Rajen Bora, something. Probably Rajen Bora. I forgot the name. They just came and it took very long period. There the court passed an order because since the matter went for a long period, people have retired and there were different cases, different charges were there, but cognizance was taken later. By the time some of the suspended persons and everything, they were retired.
But in the present case, Lordship, he was in service when he was charged.
No, that is not even my case.
So, Lordship, the 4
No,
years.
that is not even my case, my lord.
Okay,
The
he
judicial
wants to-
proceeding says
What he wants to say is that it was beyond 4 years period.
No, that is not my case at all.
Okay, let us hear.
They are on the wrong track. My case is no such judicial proceeding, if not instituted. Date of institution is 31/3/12. While the officer was in service, whether before his retirement or during his re-employment, shall be instituted in respect of a cause of action. I'm on the cause of action, which arose or an event which took place before more than 4 years before such institution. 31/3/12 is the cognizance, is the date of institution, and the cause of action is 1999. 1999 is beyond 4 years prior to 31/3/12. Therefore, it could not have been instituted at all.
Give us the dates.
My lord. The admitted position of facts date-wise in a timeline are the alleged incident is of 1999. Lordship finds the reference at page 26 of the Ejahar. The Ejahar was lodged on 2nd of September 2002. The cognizance was taken 2nd September 2002, that's the Ejahar. The cognizance was taken on 31st of March 2012.
When the charge sheet was filed?
Charge sheet, I'll check up, 36. That
On which date cognizance?
33/12, 30th of March 2012. 30 March 2012. The cognizance was taken on 31st of March 2012.
So, yes.
What I am on, my lord, if the incident is of 1999 and the institution of judicial proceeding is the date of cognizance, that is 31/3/12, applying the law which holds good as on date, it is prior to 4 years of the cognizance. Therefore, institution and continuation of the judicial proceeding is bad in law. I am not on the retirement part. It's a different issue. I superannuated on 28th of February 2018.
What is the prayer here?
My Lordship, page 18. To finalize and make payment of the regular pension as well as leave encashment and death come retirement gratuity and other retirement benefits entitled to the petition, and that's already. Because of the judicial proceeding, of which I say the institution is bad in law, my emoluments and my dues have been withheld.
Whatever the criminal proceeding there against you.
My lord.
First of all, will you able to the Reed court decide, or it is the some other court has to decide?
So far as a criminal proceeding is there, initially we filed a criminal petition. There was an order of stay. Then the stay was that the petition was dismissed. As against that, move the apex court at page 46 of the apex court order. That is holding good as on date.
46.
46. An honorable division bench of the apex court. May I read? A substantial question of law arises.
Still
in this,
pending.
my lord.
This issue is still pending before the court.
Yes, yes.
Or it has been decided.
No, stay is pending.
So you
There is
approach
stay
the
order.
court after this matter is decided.
Yes, yes.
Because when this matter is pending and
under adjudication before the Honorable Apex Court. How would you interfere at this?
See, my lord, if I may submit most humbly, my lord, since the proceedings are stayed by the Honorable Apex Court, I am on my release of pension. For that, if I may, lordship, invite my lord's attention to page 48. Page 48 is a writ petition decided by this Honorable Court on a similar count in respect of the same ejahat of a person who was also alleged. Very near. And the operative part of the order starts from page 60. Therein, the gentleman retired on 30th of September 11 as a project officer.
He was not in service when he was short-sheeted.
No, we are not on that.
This is
madam.
not a
We are on the
similar case,
principle of law.
lordship.
Have you filed your affidavit?
Affidavit, we have not.
Why have not filed your affidavit till? I will place your case in that case.
2 weeks, lordship, kindly grant me 2
Giving time
weeks.
will not do, madam. By this time, at least you should have the written instructions.
Instruction, lordship.
My lordships, whatever be the outcome of the criminal case, so far as pension rules are applicable, the judicial proceedings would be deemed to be instituted on a date of cognizance. Therefore, the power under 21 cannot be exercised to withhold my pension. The release of pension is a inevitable conclusion, regardless of any punishment which I get, if at all. There's an order of this Honorable Court in the same incident after the Honorable Apex Court's order, my lord, which we have annexed here. My lordship, there's another view of the matter. My lord, so far as the date of stay order by the Honorable Apex Court is concerned, that is 25th of June 2013. Now, another gentleman similarly placed and named in the charge sheet and all had approached this Honorable Court, and this Honorable Court was pleased to allow that writ petition on 20th of May 2014 after the Apex Court order. And at page, my
You have
lord,
annexed that copy.
60.
That order of Honorable Justice by pay, right?
There's a difference to that, my lord. The Honorable Single Judge had observed. Moreover, in the instant case, the criminal proceeding in the question against the petitioner has now been stayed by the Apex Court by the interim order dated so and so, passed in so and so, so and so and so. My lordships, bowing down to the view which has fallen from your lordship, that would be a different view of a coordinate bench to what has been concluded after noticing the order of the Apex Court. It can go either way, my submission, my lord. Because a gentleman whose name was also there has got the benefit of this provision of law by this interpretation upheld by this Honorable Court in the same Ejahar and the charge. On the same count, I pray for intervention. Actually, I'm not even addressing the matter, you know, that's a different aspect of it. It's 60 paragraph 8 makes it clear. The analogy which was followed.
Charge sheeted after his retirement, lordship.
No, that is not relevant. It's
That's why it is
alleged
not similar,
incident.
lordship.
May I just read?
Because in the present case, the judicial proceeding starts when he was in service, lordship.
No, she's
You are representing whom?
Lordship, Agriculture Department.
the projection by the respondent is not at all our case, you know. We are on the date of incident
That's why
and the
lordship
institution.
21C doesn't
In be-
apply to his case. lordship.
In between, whether they were in service or not is regardless.
Who is representing respondent number 2? Chakraborty will appear. You have heard what is the argument placed by
Lordship, I have received one instruction, Lordship, from Pension and Public Grievance Department, Lordship. There is no role to play, Lordship. They have stated that.
Lordship, if timely comes to 21C, lordship, no such judicial proceeding if not instituted while the officer was in service. The judicial proceeding was instituted when he was in service in the present case, lordship.
No, it reads further. Whether before his retirement or during his re-employment. We cannot pick and choose a phrase. It reads further in 3 instances.
In the similar order that he has annexed, lordship, the judicial proceeding started after he retired, lordship.
No, I am regardless of the retirement in both the cases. On the alleged incidents and the institution. That is where the law is attracted.
So the count of 4 years, lordship, doesn't count. It is from the date of retirement, lordship, because in the present case, he was in service when the judicial
He is
proceeding was
receiving
initiated.
provisional pension?
Provisionally,
Yes.
he is receiving it.
Mother, if I may clarify, I am not on the date of retirement. Date of retirement is relevant only for the release of pension. On the count of 21C, 2 dates, the date of the alleged incident and the date of initiation of proceedings, mother, the institution. The institution and the alleged incidents, 99 and 2012. There's a huge gap. And the same view is taken, page 60, paragraph 8, by this Honorable Court named Miller, which says, as already found by me, the criminal proceedings pending against the petitioner aroused out of a cause of action which had taken place is 99, for which a charge sheet was filed in 12. 99, it goes on different track. To 21C, if I may read again, no such judicial proceeding, if not instituted while the officer was in service, that is A, whether before his retirement or during his re-employment, BC, shall be instituted in respect of a cause of action which arose or an event which took place more than 4 years before such institution. Date of retirement is irrelevant here.
Why?
It's
Because
the institution of the event, the cause of action and the institution. And the institution has been explained to be the date on which the cognizance is taken. If it comes from a complaint, it's one way. If it comes from a GR case, that's a charge sheet. That is why I referred 30th of March, the charge sheet was submitted, and 31st, the cognizance was taken. Either way, it's a day here and there. ৰিটায়াৰমেণ্টটো লগা নাই ৰিটায়াৰমেণ্টটো দিয়া নাই কজ অফ একশ্যন আৰু ইনষ্টিটিউশ্যন
Mr. Ascoli, counsel for the petition. And Ms. Bora,
Morning,
standing counsel for the respondent.
Morning, Chilo.
Mr. A. Chakraborty, Government Advocate Assam.
2 and 5.
For the respondent number 2 and 5. Standing counsel A. J. Assam for the respondent. The petitioner hearing was an employee of the Agricultural Department of the state. During his service tenure, Vigilance Police Station case number 02/2004 was initiated. in which the petitioner was one of the accused. During his service relocation, on the basis of an FIR dated 02/09/2002. Who lost the FIR? Okay, the person to an FIR.
BSP, Bureau of Investigation, Economic Offenses, 29.
02/09/2002. Lost by Deputy Superintendent of Police, Bureau of Investigation, in bracket economic offense. Pertaining to swindling out of government money on several courts. Pertaining to supply of substandard materials at exorbitant price. Utilized in the implementation of low-cost greenhouse cum rain shelter scheme. Lost by district rural development agencies of 21 districts of Assam, India, 1999. Pursuant to which litigation, Vigilance PS case number such and such was registered. Search it, received vigilance. Case number 02/2004. Under sections
Thirty-four.
proceeding the case was filed on 30/03/2012 by charge sheet number 08/2012 and the learned special judge Guwahati on 31/03/2012 took cognizance of the offense against the petitioner and other accused persons of the case.
When did the prosecution sanction was given?
It was not given. That is at page, that is the crux of the matter before the apex court.
You have also not given prosecution
No,
sanction?
no, no. It was at page 46, a substantial question of law arises in
Then
this.
goes everything. This was nothing to do.
That's what. The apex court
That's
order,
the
my
main issue.
Not sure.
You have not, till date, you have not given
Absolutely.
prosecution sanction. You cannot have both
That's my
ways.
case. This was whether the court can proceed with the prosecution of a government servant even when the government refuses sanction. Page
Whether
47.
the requirement of prosecution sanction, the apex court have clearly laid down in the law. So there are two ways. The matter is pending before the government for the prosecution sanction. Only when the prosecution sanction will be given, the special judge will be able to proceed with the matter. Unless such prosecution sanction is not given, what will be the state? You have not given the prosecution sanction. At the same time, you have also not released his pen.
Regarding the prosecution sanction, no, Chief.
There's another thing also, Milord. Rule 21 contemplates that I must be found guilty. If the proceedings have stayed, given Rule 21 applies, they cannot hold back my pension, Milord. I must be found guilty in a departmental or judicial proceeding, regardless of 4 years of the incident occurring prior or later. That submission may be recorded.
Their instruction was to pay.
The authorities in the agricultural department as well as the personnel department of the state.
Lordship, their instruction I have to take, Lordship.
Hasn't given the prosecution sanction. It is in the order.
It's in the order, Milord.
To proceed against the petitioner and other accused persons in terms of the search sheet filed in the said Vigilance PS case number 2/2004. 3003. In spite of taking cognizance of the offences. In the meanwhile, the petitioner retired from service
28th of February 2018.
as Joint Director of Agriculture within the NZ Das Capital Roman 2, Command Hamaji on 28/02/2004, attaining the age of superannuation.
In the narration of facts, my lord may kindly refer to Rule 21 found guilty part. I have not been yet found guilty to exercise Rule 21 by the Governor of Assam.
If I pray, Lordship, the matter may come up next week, Lordship. I'll be clear with the facts, Lordship, and place it before your
We are on the
Lordship.
law.
When did you retire?
28th of February 2018. Stated in paragraph 2, page 4.
Do petitioner has been provided with pension with effect from 1st of March 01/03/2018. as well as medical allowances are admissible under the rules. But he hasn't been paid the final, he hasn't been paid the regular pension. And date come retirement gratuity, etc. So he had approached the authority concerned, the agriculture department. The respondent authorities in the agriculture department did not submit the pension proposal of the petitioner. The Accountant General as the vigilance case against the petitioner being such and such is pending before the learned special judge. Summit. It is to be noted herein that where is SLP order?
Page 46.
The special case number 19 public 2012 arising out of vigilance PS case number 02. Noted here in petitioner. In special leave took appeal within the criminal close number 080/2013. The Honorable Apex Court by order dated 25/06/2013 stayed the further proceeding of the special case number 19/2012 arising out of vigilance PS case number 02/2004 along with special case number 24/2012 arising out of vigilance PS case number 1/2004 presently pending before the learned special judge Summit. On being inquired, Mr. Bonnie Claret, counsel for the petitioner, stated that the said special leave to appeal criminal number 5080/2013 is still pending for disposal, still pending for adjudication before the Honorable Apex Court. And the said stay order dated 25/06/2013 is still in force. The claim of the petitioner for his regular pension solely on the basis of Rule 21 of the Assam Services within bracket pension rules 1961.
Firstly, on the count that I have not been found guilty of grave misconduct or negligence during the period of service, which is a precondition of 21 to withhold my pension. Then the second limb of institution.
Stating that that during his tenure in service under the government, up to 2018, he was not found guilty of grave misconduct or negligence. And though during his service tenure, cognizance was taken against him by the learned special judge in special case number 19/2012 arising out of vigilance PS case number 02/2004. But the respondent authorities in the agricultural department, the state, as well as the personnel department, has not given any prosecution sanction to proceed against him. Mr. Banik, learned counsel appearing for the petitioner, also relied on the provisions of 21C as well as the explanation A and B specified in Rule 21 of the 1969 pension rules. With regard to Mr. Banik further stated that with regard to the similarly placed an employee of the agricultural department of the state involved in the same case, Mr. Banik,
same case.
In the same case, it is placed before the court that
In charge sheet is 29 and 32.
20/05/2014, a coordinate bench of this court in WPC number 4999/2013 directed the respondent authorities in the agricultural department to pay regular pension to the petitioner of said case within bracket Nurul Islam versus State of Assam and 4 others. Notice in this case was issued on 23/06/2020. But till date, neither the respondents in the agricultural department of the state nor the Department of Pension and Public Grievances respondents and the political within victims vigilance self bracket closed department file its affidavits in the matter. The respondents shall file their individual affidavits on or before 29th of August, serving copy of the same to counsel for the petitioner. Thereafter, the petitioner shall file his replies, if any, th of September, placed on 14th of September.
Admission and endeavor of final disposal.
For admission.
Matter relates to minimum scale of pay, non-payment of minimum scale of pay.
Mr. Gogoi,
Not covered otherwise, my lord, as per the Upenda skills. 10 years, my lord, is not there.
have you stated somewhere? You file your application.
Yes, ma'am.
Why they are not covered?
Well, the Upenda judgment says that, my lord, they will have to work for minimum 10 years till the date of passing of the Upenda judgment. Here, my lord, they were engaged in, so far as the first case is concerned, in 2008. So a person, in order to have the benefit, will have to at least join, my lord, before 2007. At least, my lord, in May 2007. That is our understanding.
So you are saying that Upenda's case, the division bench consider conclusion,
Yes.
considering the date of the judgment.
Yes.
That they have to render
It is a statement.
10
is
years
there.
of service.
Yes.
As on that particular date.
Yes.
And whoever has joined that service will get the benefit of.
My lord. My lord.
But here in that case, the petitioner joined
2008.
So
So going by this, my lord, in 2007, July 2007, it's not 10 years. That is our precise case. But they are relying on Jagdish Singh. According to them, the Honorable Supreme Court has not laid down that benchmark of 10 years. But, my lord, since the division bench has passed this order of this principal seat, my lord, so this is binding on us. If they agree, my lord, they will have to take that, my lord, argument before the division bench by a review application, or they will have to move the apex court. That's our stand, otherwise, legal, on the legal side.
yes, Mr. Sakya,
My lord. My lord, first of all, my lord,
considering this thing,
yes, my
the
lord.
division bench passed the order into Upenda.
Yes, my lord. That case was my lord consensus order, my lord. When this case was a consensus order, my lord, the entitlement of my lord, minimum scale of pay was not decided there. It was the government, my lord, who proposed that. As those persons, my lord, sought for regularization, when it was found that regulation is not permissible, government came out with a my lord, proposal that they will be given the minimum scale of pay in view of the law laid down in Jagdish Singh case. My lord. But subsequently, my lord, in the Subhashankar Dubey also, the Honorable Apex Court has held that, my lord, these persons are entitled to the minimum scale of pay when they are rendering the same service, same qualification, they are entitled. So, my lord, that 10 years criteria.
Whoever joins in service in business, or workers or will be entitled for scale of pay, minimum scale of.
Yes, my lord.
The rules, minimum scale of. What's the? You are entitled for it, as per the act.
Singh case, my lord, paragraph 55. If your lordship take up. Paragraph 58.
Just a minute, coming to that. You are relying Jagjit Singh, right?
Yes, my lord. Jagjit Singh and Subhashankar Dubey, my lord.
Paragraph 55 of which case?
Paragraph 58, my lord, Jagjit Singh. Jagjit Singh, my lord, 2017 1 SCC 148.
A 58 in our consideration. In our consideration, 58.
In our considered view.
$58.
58 and 60, my lord. Fifty-eight, 60, and 61.
Yes.
In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities. Certainly not in a welfare state. Such an action, besides being demeaning, strikes at the very foundation of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family at the cost of self-respect and dignity, at the cost of his self-worth, and at the cost of his integrity. For he knows that his dependents would suffer immensely if he does not accept the lesser wage. Any act of paying less wages as compared to other similarly situated constitutes an act of exploitative enslavement emerging out of a domineering position. Undoubtedly, the action enslavement, the action is oppressive, suppressive, and coercive as it compels involuntary subjugation. That is the paragraph 58. Paragraph 60, my lord. Having traversed legal parameters with reference to the application of the principle of equal pay for equal work in relation to temporary employees, daily wage employees, ad hoc employees, employees appointed on casual basis, contractual employees, and the like, the sole factor that requires to our determination is whether the employees concerned were rendering similar duties and responsibilities as were being discharged by the regular employees holding the same corresponding post. The exercise would this is some next. Lakshmi, kindly turn to page paragraph 61. In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that the temporary employees concerned in the present bunch of cases would be entitled to draw the wages at the minimum of the pay scale at the lowest grade in regular pay scale extended to a regular employee holding the same post.
So you are serving as what?
I'm working as a copyist in Foreigners Tribunal.
Copyist of?
Foreigners Tribunal.
We are also
Same. All the petitioners are working as
all are copies.
All are copies.
Since when?
Since the petitioner before lawsuit is working since my lord 2008. 12/9/2008.
What is the minimum of the pay scale of a copyist?
Minimum of the pay scale of a copyist, they have granted to the other copyist at page 35 of the petition, my lord.
No. Regular appointed. So 12,000 is the minimum scale.
Yes, my lord.
So you are claiming on the basis of this case, everything, right?
My lord.
Para 61.
Para 61.
Living assertion because other things are approved.
My lord. But another judgment, my lord, I am relying on. That is 2019 12 SCC 297.
Yes. Yes.
My lord, here, my lord, perhaps my lord, paragraph will not be same because my lord, I have taken the judgment from another website, my lord.
Tell us, it starts with the first.
My lord, paragraph 9 on comprehensive consideration.
Just a minute.
My lord. In paragraph 10, my lord, paragraph 58 of my lord Jagdish Singh has been quoted. Paragraph 11, my lord. The issue that was considered by this court in Jagjit Singh is whether temporary employees, daily wage employees, ad hoc employees, employees appointed on casual basis, contractual employees, and likewise are entitled to minimum of the regular pay scale on account of their performing the same duties which are discharged by those engaged on regular basis against the sanctioned post. After considering several judgments, including the judgments of this court in Tilak Raj and Surjit Singh, this court held that temporary employees are entitled to draw wages at minimum of the pay scale which are applicable to the regular employees holding the same post. In view of the judgment in Jagjit Singh, we are unable to uphold the view of the High Court that the appellants herein are not entitled to be paid the minimum of the pay scales. We are not called upon to adjudicate on the rights of the appellants relating to the regularization of their services. We are concerned only with the principle laid down by this court initially in Kuttilal relating to persons who are similarly situated to the appellants and later affirmed in Jagjit Singh that temporary employees are entitled to minimum of pay scale as long as they continue in service. We express no opinion on the contention of the state government that the appellants are not entitled to the reliefs as they are not working on Group D post and that some of them work for short period in projects. For aforementioned reasons, we allow these appeals and set aside the judgment of the High Court holding that the appellants are entitled to be paid the minimum of pay scales applicable to regular employees working on the same post. It has only followed the missing case, and Kuttilal. So,
Mr. Gogoi.
First of all, my lord, one submission.
Note down, there is a finding, that's why. Otherwise, in terms of Jagjit Singh and others,
yes,
you are supposed to pay. There are
yes,
61 letters.
yes,
But you have a handle. The handle was given to you. in
Para
the case
22
of
Upenda.
State of Haryana versus Tilapras.
Yes.
There are 11 and 13. If you can establish, because one type of copies are having sanction post, another type of copies they are
Yes.
on
I know your
wages,
point. Yes.
not on salary.
Not
on
on
wages.
sanction post.
If you can show that there are differences, there of nature, that is the handle given to you, para 11 and 13 of the Tilapras.
My lord. No, my lord. Apart from that, my lord.
You
Apart
have
from
the
that,
Tilapras with
the
you?
one submission, my lord, I would like to clarify made by the petitioner that this Upenda's judgment, my lord, para 22 is a consensus order.
No.
Not a consensus order. So
See,
far as
that
the
is
main,
Upendas's case has come because some of the employees are left out from regularization.
Yes.
That is the background.
not all, some, my lord,
Not
because the
all, some.
policy was 1 for 1993. So, my lord,
So those were similar
no,
benefit they
beyond that, it has been considered.
All
Beyond
those
that, is-
persons were
because
appointed.
my lord, there is a notification of the finance department considering para 53 of Uma Devi. Because there is a order, my lord, past that, my lord, all the state will have to take out the one-time measure exercise and my lord will have to regularize them, provided they my lord, fulfill the 3 conditions laid out in para 53. That we have done in 2013. Now, my lord, those who, my lord, do not qualify under those 3 criteria, they, my lord, considering their prayer for regularization, which was denied, the following Jagjit Singh, my lord, the minimum of the pay scale was granted. That is the whole gist of this, my lord, particular case of Upendas. Now, my lord, though, my lord, the state government, my lord, considered before the division bench that, my lord, regarding their health insurance and all, though they are not entitled, the state will look after it. They will form a policy or whatever is required, that will be done. But regarding the minimum of the pay scale, there is a specific mandamus issued by the division bench. It's not a consensus order on that part.
Now, paragraph 21. They
Para
come up with a
22,
proposal.
Lordship may kindly see. Para Jagjit Singh.
Upendas.
No, I'm sorry, man, Upendas. Para 22.
Yes.
May I read it, madam? It is, however, heartening to learn that the state government has agreed not to terminate the master worker, workers, and similarly placed employees working since last more than 10 years, not in sanction post, till their normal retirement, except on disciplinary ground or on the ground of criminal offense. The state government has also agreed to enlist such employees in health and accident and death insurance schemes, which will be prepared in consultation with the state cabinet. We appreciate the positive stand of the state government taken as a welfare measures for the betterment and security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Besides this, this is the mandamus issued to us. We, in the light of the decision of Supreme Court in State of Punjab versus Jagjit Singh, also direct the state government to pay minimum of the pay scale to the master workers, workers, and similarly placed employees working since last more than 10 years, not in sanction post. with effect from 1/8/2017. So this part, my lord, from the line, my lord, besides, here, my lord, the entire crux lies. Though, my lord, admittedly, it was not there, my lord, the 10 years, my lord, benchmark is not there in, my lord, Jagdish Singh. But the division bench of this honorable court, after considering the judgment of Jagdish Singh, as well as the cases of the similarly placed employees, have, my lord, finally issued an order that, my lord, only those employees who are working since last more than 10 years, not in sanctioned posts, they will be entitled for the minimum of the pay scale. Now, my lord, if at all they are finding any fault in this particular, my lord, order, only courts left out for them is to, my lord, approach the apex court. Because Lordship may kindly see this judgment of Sabha Shankar, which has been just now realized by the petitioner, reported in 2019-12 SCC. Lordship may kindly see para 9 for a moment. 2019-12 SCC.
Yes.
Para 9. Lordship will see, my lord, para 9, last 5th line. The division bench of the High Court also cited Surjit Singh to hold that the daily wagers cannot seek the benefit of judgment of Puttilal case in view of the subsequent decisions of this court, wherein, according to the High Court, it was held that daily wage employees were not entitled to the minimum of the pay scale. This was the finding of the division bench. Challenging this, my lord, they approached the apex court. Herein, my lord, so far as our, my lord, court is concerned, but there is a, my lord, standing judgment of this honorable court, considering, my lord, Jagdish Singh. Now, if they agree by that, my lord, their only courts, my lord, left out for them is to, my lord, approach the, my lord, apex court, if at all. Because, my lord, this particular judgment of the division bench is binding before this honorable court, my lord. Because it says, my lord, all similarly situated persons will be covered in, my lord, Upenda. It says, my lord, besides this, we in the light of so and so, also direct the state government to pay minimum of the pay scale to master roll workers, worksite workers, and similarly placed employees. So, my lord, if they agreed by this, my lord, 10 years benchmark that has been, my lord, added in this particular judgment of Upenda. My lord, only course, my lord, left out is to, my lord, prefer a review application against this, my lord, citing this judgment fund. And, my lord, regarding, my lord, Jagdish Singh, Lordship may kindly turn to para 42.10. Just, my lord, few cases are there, my lord, I'd like to point out.
Hmm.
42.1, page 206. 42.1 says, my lord, the onus of proof of parity in duties and responsibilities of the subject post with the reference post under the principle of equal pay for equal work lies in the person who claims it. They will have to demonstrate before this honorable court first in their writ petition that these are the responsibilities which have been done by the, my lord, regular, similarly placed regular employees, and they perform the same. Then we will counter, my lord, and this honorable court will decide thereafter. The onus is upon them, my lord. They will have to demonstrate. There is nothing in the writ petition to show that, my lord, they perform the same duties. And on top of that, my lord, the Upenda's judgment is there. Their whole contention is, my lord, they want to rely upon Jagdish Singh, my lord, leaving aside Upenda's. Whether, my lord, that will be possible, my lord. In fact, my lord, from 42.2.1 to, my lord, 42.17, 17, the Honorable Apex Court has, my lord, broadly, my lord, has dealt with this particular principle, that is equal pay for equal work. Now, again, my lord, 43 onwards, it's regarding pay parity of, my lord, between the casual employee and a, my lord, regular employee. It has been, my lord, broadly discussed, and finally, my lord, the order is at page para 55, 61 of the existing, para 61. Now, following this judgment, my lord, rightly or wrongly, an order has been passed and we have implemented it.
Yes, Mr. Sakya.
My lord. My lord, first of all, my lord, the case of
Last
Upendas.
part of the Upendas, para 22.
Yes, my lord. My lord, first of all, Upendas is a case, my lord, where the petitioners therein, my lord, they sought for regularization of their services. All of them were, my lord, appointed prior to 1.93. They were the left out master workers, my lord, master of the other similarly situated workers whose services were not regularized. And, my lord, for them, question of 10 years, my lord, was not a matter at all, my lord, in the year 2017. Because they have completed more than 10 years at that point of time. So, my lord, and their case was for regularization only. Entitlement of minimum scale of pay was never decided in the case of Upendas, my lord. It was only a direction to grant the benefit to those persons, my lord. And in that judgment, my lord, it was never held that those persons who have not completed 10 years of service, they are not entitled to the minimum scale of pay. It was never held, my lord. So, my lord, as that issue is not decided by the Honorable Division Bench, following the judgment of my lord Apex Court, my lord, Lordship may direct the authority, my lord, now. No.
What about your obligation to show?
Yes, my lord, I have stated.
The parity.
Yes, I have stated in my petition, my lord,
First
additional
of all, you
evidence.
have to show if there is similar kind of work you are doing or not.
Yes, in my lord, page 53, you will also come to page 53. That is my additional affidavit, my lord. Paragraph 4.
Affidavit, additional affidavit.
Yes, my lord. The issue was, my lord, raised by the Learned Council for the respondents, my lord, wherein, my lord, the my lord, it was filed on 27/5/2022, my lord. Paragraph 4, my lord. That the deponent begs to state that she is engaged and doing the same amount and same nature of duties and responsibilities like that of a regular copyist working under various honorable courts all over Assam, and also the copyist working in other foreigners tribunal in Assam. Therefore, she cannot be deprived the minimum scale of pay by making an artificial parameter. And this was never, my lord, controverted by the respondents, my lord.
Mr. Who is appearing for the personal department? For whom department? Who is appearing? You are appearing for whom?
I am appearing on behalf of Lordship. Number 1 and 2, Lordship. Political department, Lordship.
Whether the member of the foreigners tribunal can employ somebody as an ad hoc person.
Under ad hoc.
Please come to annexer 1 of the first. Is number 16.
Kind attention, my lord. The persons, my lord, who were granted the minimum scale of pay, the copyist, at page 35, all of them were appointed by the member of the governance tribunal. Because some of them were my clients, my lord, that I know.
So, is temporarily appointed copies and of Lordship, I found it.
Okay. So,
in 12/9/2008.
Whether the member of the foreigners tribunal is empowered to appoint somebody on ad hoc basis or on regular basis.
Lordship, that part my brother can answer because he is standing as a foreigners tribunal. He may answer it also.
Is he empowered?
Lordship, on ad hoc basis, it was not mentioned, Lordship. Assam Foreigners Tribunal Establishment Ministerial Service Order 2012, Lordship. Their rule order 10, Lordship, order 11, Lordship, mode of appointment. Here it was written as the grade 3 and grade 4 staff of the service shall be
appointed by the member Foreigners Tribunal. The employees of Foreigners Tribunal are district level posts and they shall be in the concerned Foreigners Tribunal where they are appointed. However, in exceptional cases, government may transfer any employees from the tribunal, one tribunal to another. And other conditions of service, Lordship, the posts in all cadres are purely temporary and continue till the existence of Foreigners Tribunals. The employees shall have no claim to continue in service in case of tribunals are abolished, Lordship. And regarding payment, Lordship, all appointment in the service shall be made in the time scale of pay, as may be prescribed by government from time to time, except in case of orderly peon. In respect of orderly peon, the fixed remuneration notified by the government from time to time shall apply. And in respect of orderly peon, Lordship, it is coterminous with the tenure of the member, Lordship.
Now, this rule is silent regarding the.
Regarding ad hoc basis, Lordship, it was silent, Lordship.
Because he is important appoint on a regular
Now,
basis.
just tell us only against valid sanctioned post,
Lordship,
or the post created for that purpose,
Lord,
Foreigners Tribunal. It is the member of the tribunal can appoint.
Yes, Lord. For in respect of grade 3 and grade 4, Lordship.
Grade 3 and grade 4, the post have to be created. Right?
Yes, Lordship.
Now, will you able to test there are how many posts of grade 3 and grade 4 are there in the Borpeta Furnace type?
Borpeta, I have not taken the inspection, but in respect of Tinsukia and Lordship, Kamrup Metro District, Lordship, one post are lying vacant, Lordship.
No, that is not on that.
Lordship. In respect
Bora,
of
your cases from which district? Your cases from which district?
I am from Kamrup.
Kamrup Metro.
PC number 186 2012. Item number 37.
You are in 39. You are in 39.
38 and 39.
38 and 39. 30 is for which district?
Kamrup Metro.
Office.
Okay.
And 39?
39 into here.
Regarding Kamrup Metro and
Earlier she was
Lordship.
in Shivsagar, but that tribunal was relocated and transferred to Tinsukia.
Now this tell us one thing. In the case of item number 39,
regarding,
you have just heard what Mr. Bora had said, that it was the petitioner was earlier in Shivsagar,
Lordship,
right? Appointed by the concerned member. Now, since the Shivsagar tribunal has been relocated, there is no longer any bench, any tribunal at Shivsagar. He has been placed in Tinsukia. It has to be, that order has to be passed by the government.
Yes.
Who has placed you in the Tinsukia?
Hello?
Who placed you in Tinsukia after the Shivsagar tribunal? You was relocated, right?
Relocation order is there.
Who posted you in Tinsukia from Shivsagar? Because there has to be the order passed by the government.
A notification was issued on 11/2/2013 by the Secretary to the Government of Assam Home and Political Department. Annexure A space 30 in my petition.
When she was relocated at Tinsukia? By which order?
Relocation order is space 38, annexure A. In that order, my name was not there. Therefore, I approached before its honorable court. And I am continuing at Tinsukia.
Mr. Gogoi. Mr. Sumar, there are two things. Petitioners are here working on the contingency amount or what?
That part, of course,
You have
the
the
personal department,
you have the copy of the repetition in item number 39.
39. 39. Bonus. Well,
come to page number 31. Last slide.
contingency basis, 0 wages, 0 to wages.
0 to wages.
So if it is contingencies, it will be totally different.
Lordship.
Because our high court employees are getting something, huh? You know.
Well.
So you have to tell us whether at Barpeta or at Tinsukia or at Kamrup Metro, the petitioners who are working, their salary are paid from the contingency fund or what? The petitioner, in the case of Mr. Saikia, the petitioner might have been appointed on ad hoc basis. But salary component was from where? If it is under the, because there has to be some, because here is a mention of a notification. 0 to wages contingency. So it will be totally different.
Yes, sir. 0 to wages will the account have.
We know. But if it is contingencies, mean that it will get come at different. So you have to tell us in these three cases, because here we have seen in the item number 39, the petitioner was initially appointed on contingency fund. Right? Tell us, first of all, you have said there is no provision for appointment on ad hoc basis.
Yes, sir.
Right? Only in the regular purpose, the member of the tribunal has the power to appoint. So how many posts that you have sanctioned for the Barpeta Fairness Tribe? There are numbers of 1, 2, 3, 4, 5 tribunals are there. So tell us how many posts for each of the tribunals. And then what else you have? Right? This rule you have read from where? 2012 rules.
Assam Foreigners Tribunals Establishment in bracket Ministerial Service Order 2012.
When? Tell us, you have to clarify.
2 weeks ago.
Give us a date. Mr. Gogoi, just for the clarification of the court, is found under contingency.
My lord, that part I will.
And the wages for the MR and boxers, that is similar or different?
Lordship.
That you have to clarify.
Lordship. The 23rd.
Give us a date.
26th, 23rd or 24th.
23rd
or 25th. my lord. Or 25th, 24th.
No,
On a hearing date,
24th. On 29th will be better, my lord, because on 24th I will be out of station.
On which date?
29th.
We have 50 cases fixed.
Then 31, my lord.
Last day of the
31.
Seventh.
7th of September.
My lord, the item number 42.
ৰুলখন অকমান পাম নেকি মই ফটো ষ্টেট কৰিব ৰুলছখন এবাৰ দিবাচোন